number 1.
You could wait or call again later. ನೀವು ಕರೆ ಮಾಡೋಕ್ಕೆ
With permission, my lord, court's mic is muted.
Today. Which is Mahesh Uttin. This is entire order, sir. Not a specific order. This is entire order.
670, check, just passed on. Because here also referred to direction of no once the plan was ordered for the entire order.
Yes, please, sir. What do you say? ಅದಾಯ್ತು ನಿಮ್ದೇನು ಹೇಳಿ ರಾಮ ಆಯ್ತು ಚಾಲೆಂಜ್ ಮಾಡಿ ಅದು ನೀವು ಗೌರ್ಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್ ಅದೇ ಸಂಬಂಧ ಇದೆ ಸುಮ್ಮನೆ ಇದೆಲ್ಲ ಪಬ್ಲಿಕ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿಬಿಟ್ರೆ ಏನಿಲ್ಲ ಸರ್ ಅಲ್ಲಿ ಪಿಕ್ಚರ್ ಕೊಡಪ್ಪ CH ಪಿಕ್ಚರ್ the CC 380/2019 filed by the complainant to take action against the accused person. Namely, the Chief Secretary Government of Karnataka, Secretary KPSC, to take action on the grounds of Section 11(12) of Contempt Court Act for willful disobedience of the order passed by this court dated 21/6/2015, made in WP 41/360/2012, the connected matters. Sri Dinavarasu, Sri so and so learned counsel for the Rasapata. Ambassador, Sri so and so learned counsel for the contended that the order passed by the court and bench of this court dated 21/6/2016, made in WP 27/6/2012, connected matters, direction number 1A, B, C, D, E, not complied. Thereby, the accused violated the order passed by this court. Stop. The KPSC filed objection. Compliance affidavit on 10/6/2019 by the Secretary Karnataka Public Service Commission, specifically stated in para 3 as under page 621 again. The Rubin Jacobs, other senior counsel representing KPSC, has contended that The order passed by the court at bench of this court had been complied as long back as on 10 September 2021 and issued or produced the copy of the communication dated 4/18 before this court. Thereby, the direction number 1, A to E, has been complied. He also admitted that in the similar circumstances, the court has been at this court in contempt petition 670, 2672, 2756, 2019. Similar contention rise has been considered and held. The direction 1 has been complied. Nothing survive consideration these pictures. Accordingly, contempt proceedings have been dropped. The same is placed on record. Said fact is not disputable and considered by the complaint. Not the above, we pass the following order. The contempt proceedings here were dropped. Only there. 12.4. You same account. Yes. Ah, 2.3, yes. What is the violation, sir? All right. Vedachala, first show what is the violation. Separate cause of action. That is separate cause of action. Direction number. Yes. Yes. According to you, this third direction not followed by KPC. Yes. Where that order read? Yes. Yes. Modi. Yes, Mr. Senior Counsel report. All right, yes. ಒಂದು ನಿಮಿಷ ಇರಿ ಸಬುದಿಲ್ಲ ಅವರು ನೋಡಿ ನೋಡ್ರಿ. Yes, Mr. Read the order passed by this court 25/4/2019. You have submitted certain post cons in the implemented direction 3. However, do not find any concrete steps have been taken to implement said direction. When? After the order passed by this court.
8/2019, the notification that was issued, pursuant of direction 50. Compliance affidavit has been filed on 5/9/2019.
Affidavit filed on
5/9/2019.
5/9/2019. Sorry. 5/9/2019. Yes.
Direction of 3 of the final order dated 31st of stated, APS has completed the said exercise. The result of this exercise is published as per notification dated 2019. Published after 2019. The same has been followed by the state government. This is direction of the after the notification dated 2019. The direction after. Pertaining to state, this notification was challenged.
We are not concerned.
We are compliant with it.
Whether the present complaints also challenge that notification?
So far as complainant norms, in 668 they are not challenged.
We are concerned only 668
They are not challenged.
and 8/8/2019. All
They have got it.
all right. Yes, sir. Papa. Kindly withdraw on annexure. Yes, yes. Annexure G.
After 13 months, they have withdrawn this notification and action J. Now they are saying third month is under control. J, page 43. There is a need for withdrawing this notification, Miller. Even my member friend, when a senior counsel is not able to say this notification is subscribed to that issue. If you have been there,
What is this, Mr. Senior Counsel? Applying for the KPSC. How can you suppress?
No, I was about to say the subsequent development. This was challenged what had happened. My
Sir,
lord. As on that day,
Mr. Robok, now you are designated Senior Counsel. You should have some responsibility towards the court. Don't act like a KPSC counsel.
what happened?
As soon as I said, you said, no, subsequently that has been complied, it's wrong. You should have said that.
What happened was that thereafter one more contempt petition was filed. This Honorable Court in that contempt petition filed like notification as revised. So therefore, notes we have revised it. That order notes we have revised it. I have asked on that order notes.
For what?
The notification that
We are not concerned the contempt orders. We are concerned the original order. According to you, direction number 3 complied by Annex R1 by the approved dated 5/9/2019. Your statement is falsified. Your rejoinder Annex J. What do you say now?
Next months I made a submission. This reply note was just served to me. Subsequent, this was filed on 5/9/2019. Subsequently, much further is thrown into the bridge that notification was quashed. I was report this on the report. This on the report is state those case and orders. I will place it on record. I will place it. No, request statement is just.
We are not concerned any orders, whether the order passed by the DG coordination of this court in the 2016 has been stayed by any court.
It's compliant.
Then comply, that's all.
What we are saying is, we have complied with notes by virtue of this notification of 22/8/2019.
No, withdrawing is not compliance.
We have issued a revised notification. It is an incorrect submission. We have issued a revised notification, not simplified from notes to.
Yes. So, from the revised notification, direction number 3 has been complied.
Alexa J, page 23 notes.
Yes.
Paragraph number 3 notes. Paragraph number 2, they have extracted this.
All right. Yes.
In compliance with direction number 2, extracted Sutra, the most suggestion mentioned there was published on 25/1/2019 as revised select case. Thereafter, now this sentence is important. In compliance with direction number 3, extracted about the revised select case was published by notification dated 22/8/2019.
That is earlier.
Please.
That is earlier, sir.
22/8/2019. What is referred to in the counter affidavit?
Correct.
Now, can you see the next paragraph? Complaining that in making paragraph number 4, complaining that in making the reverse select dated 22/8/2019, the ABS is the government of deliberately which direction number 3 extracted in paragraph 2 about the taking into consideration the data number of assets. Some of the candidates across the Honorable High Court, some of the candidates agreed with the select place dated 22/8 across the Honorable High Court of under section 66 number 4 and so on. These conduct of court cases were disposed by the Honorable High Court by a common order dated 4/2020. Reading. Counter affidavit has been filed, denying the allegations to the complaint. The matter was heard substantially on the previous date of hearing, and the request of the right of suffering for responding matter today, an affidavit has been filed by the respondent content number 3 to state that in terms of direction number 3 should be directed as so and so, and corrections of taking into consideration 91 answers to give the effect of the order dated 11/10/2002, passed in the bulletin number so and so, order dated against number so and so. Because this to the ground person to the steps that will be taken to undertaking the exercise are also been indicated in paragraph 3 of the affidavit. Respondent nothing has sought for 60 days time to complete the exercise.
Yes.
In the light of state submission made the respondent
All right. Wow, 60 days over. Whether acceptable or considered.
in compliance with the above revised selection list, last paragraph. In compliance with the above, the revised selection list is hereby published for information of the candidates in this corporate government. We have revised notes 22/8. Which have complied direction number 3. Like even the revised notes, we are not written it. That is the incorrect submission. Therefore, notes I had to comply it earlier. Therefore, notes that
This revised list is in consonance with the direction number 3.
It is in consonance with direction number 3 according to us.
Yes. Yes, sir.
They only produce it.
ಇಲ್ಲ ನೀವು ಮಾತಾಡಬೇಕಿಲ್ಲ ಅಶ್ವಿನ ಕೂತ್ರು ಮಾತಾಡಬೇಕು ಯಾರೋ ಒಬ್ರು ಈಸ್ ಅಪೇಯಿಂಗ್ ಫಾರ್ ಯು ಯಾವ ಕೇಸಲ್ಲಿ 12.2 that is what you are taking 12.5 you are not taken 12.5 no notice is issued we don't know sir office objection raised ಬಿದ್ದಿದೆ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡಿ 6 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇತ್ತು ಅಂತ ಇರೋ ಸಲ Yes.
The ancestors of medium and actually the DNA and development method 128 ancestors oil. Here the lab, as a matter of fact, the main application of the question of the order. The Karnataka was reached to reject this application and by imposing a part of contact from the previous state and directing them to consider directions of the right. 128 ancestors in A name should have been considered. Nobody taking advantage of the word when given ancestors in direction of A. Now they have taken consideration only make ancestors. That is not the tenor of the order part of some. Then direction number 3 has to refer to the ancestors which were there on A9. When within the knowledge of frequency. Now intentionally by taking advantage of the word when given ancestors, they are considered only negative ancestors.
That is the order. That is the order. You challenge that separately. You can challenge that separate revised list. You are not happy, you can challenge the revised list. Please read, Mr. Ravi. No, Mr. Ravi, please read. We can't give implementation each and every word. This order is compared with Supreme Court, they are bound to follow. That's all. KPSC shall take into consideration the 91 on a skip which forms part of excess 10% revalue paper. Give effect to the order passed this court 11th September. Then you should have challenged this order. No, no. Sir, contempt alli navenittu yenilla anta madak baradilla. What is the order, whether complied or not? If account you not properly complied, revise notification issued, challenge that.
When we see the one two of the order is unquote. The error of 2 and 2.
Two, you are re-arguing the matter. Supreme Supreme Court. Sir, so many findings now Madidivi. Ultimately, what is the direction issue? That is important. Merely finding you said something. This is upper. We have ultimately said a 91 answers skip part 10% ಅದು ಮಾಡಿದ ಇಲ್ಲ ಅದು ಮಾಡಿಲ್ಲ ತಪ್ಪು ಅಂತ Mr. Senior Counsel, please, there is no now you can't interpret in contempt proceedings, sir. This order is affirmed.
I am not asking the law to interpret the right. I am asking the law as to the point whether any order may not be supported by the findings of this court.
Now, the order passed by this court directing KPSC shall take into consideration 91 answers skipped which form part of excess of 10% of revalued paper, give effect to the order of the so and so, in so and so, that is the order. Now they are given effect too. ಅದು ಸರಿ ಇಲ್ಲ ಚಾಲೆಂಜ್ ಮಾಡಿ 91 ಆನ್ಸರ್ ಸ್ಕಿಪ್ ಮಾಡಿದ್ದಾರೆ ಅವರು. ಇದು ಈ ಜನ್ಮಕ್ಕೆ ಸರಿಯಾಗಲ್ಲ. No, problem is, sir, problem is this contemners, they are unhappy. They should have challenge. They want interpret, no problem. All right, 215.
Understanding direction of peace consent. The themselves made an application. Understanding that this visual direction should write be pertain to A9 access.
Now you have produced the revised list, complaint that's number 3. How it is bad? Show from that part.
My advisor says
Though courts, lawyers, and as well as government KPSC encouraging all these things for all from 98. ನಾವ್ ಅದ್ರಲ್ಲಿ ಎಷ್ಟು ಕಾರವಾಗಿ ಬರೋದು ಅವ್ರಿಗೇನು ಮಾನ ಮರ್ಯಾದೆ ಇಲ್ಲ, ನಾವೇನ್ ಮಾಡ್ಬೇಕು? ನೆಟ್ಟೆ ಮಾಡ್ರಿ ಕೆಲಸ ಅಂದ್ರೆ ಅವ್ರು ಮಾಡೋದಿಲ್ಲ. ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಯು ವಾಂಟ್ ಆಲ್ಸೋ ಎಂಜಾಯ್ ವಿತ್ ಕೋರ್ಟ್, ಮಜಾ ಮಾಡಿ.
ನಾನು
ದಟ್ ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್. ಅವ್ರಿಗೆಲ್ಲ ಫಲವತ್ತಾದ ಜಾಗನೇ ಬೇಕು, ಫಲವತ್ತಾದ ಜಾಗನೇ ಬೇಕು. ಎಸ್ ಸರ್, ಜೈ. Yes. Yes.
And the serial number 11, assistant commissioner. Then the second revised list.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್. ನಾವು ಆರ್ಡರ್ ಬರೀಬೇಕಾದ್ರೆ ಯಾವ್ಯಾವ ಕ್ಯಾಂಡಿಡೇಟ್ ಎಲ್ಲಿ ಇರ್ಬೇಕು ಅಂತ ಬರ್ದಿಲ್ಲ ನಾವು. ಈ ಕ್ಯಾಂಡಿಡೇಟ್ ಇಲ್ಲೇ ಇರ್ಬೇಕು, ಈ ಕ್ಯಾಂಡಿಡೇಟ್ ಇಲ್ಲೇ ಇರ್ಬೇಕು, ಇಲ್ಬೇಕು ಅಂತ ಹೇಳಿಲ್ಲ. 91 ಇದು ತಗೊಳ್ಳಿ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದೀವಿ. ನಾಟ್ ಹ್ಯಾಪಿ, ಚಾಲೆಂಜ್ ದಟ್ ಆರ್ಡರ್. Mr. Ravi, we are passing this order from 98. We are also human being. Repeating. Different lawyers, different judges, wasting public time. ಇದರಲ್ಲಿ ಅಪ್ಲಿಕೇಬಲ್ ಸೆಕ್ಷನ್ ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿ ಮಿಸ್ಟರ್ ವೇದಾಚಲ. Yes, who appears any other matters?
12.5 minutes. I appear in the CC number 166.
All right. Yes, 12.1. Yes, what is the violation, madam?
My lords, once the directions have been complied, my lords, subsequent to that, my lords, the other benefits follow, my lords. That is with respect to fixation of the seniority, my lords.
But you can challenge separate proceedings. Benefits not followed, you can't interpret in contempt proceedings, whether complied or not, that's all.
My lords,
That
that's
is
been
separate proceedings.
my lords, we have filed an IA. We have filed an IA, my
Don't
lords.
leave these people. ಅವರು ಅಲ್ಲೆಲ್ಲ ಹೊಡಿತಾರೆ. Don't leave these people.
I have
They are
filed an
ಕಾಮಧೇನು. ಬಿಡಬೇಡಿ. I request all the advocates, don't leave this. ಯಾಕಂದ್ರೆ ಅಲ್ಲೇನು ಅವರು ಕಷ್ಟಪಟ್ಟು ದುಡ್ಡು ಕೊಡಲ್ಲ ನಿಮ್ಗೆ. Yes. Yes, ma, what is the violation?
My lords, that is the they have not given us the consequential benefits, and the fixation of the seniority is not.
Madam, consequential benefit ಕೊಡಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ ತೋರಿಸಿ ತಾಯಿ.
ಅಲ್ಲ ಅದೇನಾಗುತ್ತೆ ಅಂದ್ರೆ once they complete, this will follow, my
Madam,
lords.
please.
These benefits will follow, my lords.
This is a contempt proceeding. There is no scope for interpretation. What is the violation? Show us. We will punish. With consequential benefits, we will challenge separately. ಕೊಡ್ರಿ ಇವರು ಫೈಲ್ ಕೊಡ್ರಿ. What is this, ma?
That liberty may be given, my lords. That may be observed, my lords. Kindly.
Sorry. Yes, ma. Show us what is the violation.
My lords, I have filed an IA, my lords. That's on 31/7/2019.
They are taking your contempt petition.
Yes,
You
my
are
lords.
seeking contempt against the violating the order dated 21/6/2016. What is the violation?
My lords, after that, they have complied, my lords. They have complied with the orders of the court, my
Become
lords.
infractors.
My lords, then I have filed an IA, my lords. My lords, with
For what?
respect,
For what?
my lords, kindly see
Yeah,
IA,
yeah.
my lords. IA filed on 31/7/2019, my lords. For direction, I have filed, my lords.
For what? ಏನು ಡೈರೆಕ್ಷನ್ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ?
Direct the first and the second.
ಕಂಟೆಂಪ್ಟ್ ಏನು ಡೈರೆಕ್ಷನ್ ಅಮ್ಮ?
ಅದೇ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಆರ್ಡರ್ ಕೇಳ್ತಾ ಇದೀವಿ, my lords. ಅದರಲ್ಲಿ ಅದೇ
Clarification.
ಅದೇ ಸೀನಿಯಾರಿಟಿ ಫಿಕ್ಸ್
Stick to the original order.
my lords, seniority ಇದೆಲ್ಲ ಮಾಡಿಲ್ಲ, my lords. They say that they have complied with the orders of the court, but after that it is
ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಸೀನಿಯಾರಿಟಿ ಬರಲ್ಲ. ಇಲ್ಲಿ ಆರ್ಡರ್ ವೈಲೇಷನ್ ತೋರಿಸಿ ಪನಿಷ್ ದಮ್. seniority separate proceedings ಅದೆಲ್ಲ ಕೇಟ್ ಇಲ್ಲಿದೆಯಲ್ಲ ಇರ್ಲಿ ಅಲ್ಲೇ ಕೇಟ್ ಇಲ್ಲಿದೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಮುಂದೆ ಬೇರೆ ಬೇರೆ ಎಲ್ಲ ಇದೆ ಕೊಡಪ್ಪ ಏನಾಗಿ ನಿಮ್ಮ ಅಯ್ಯ ಎಷ್ಟು ತಾಯಿ
IA, my lords, it's filed on IA 2, my lords.
ಇವಾಗ ಕೋರ್ಟ್ ಓಪನ್ ಮಾಡಿದ್ರು ನಿಮ್ದು ಇದು ಆಗಿಲ್ಲ ಅಲ್ಲೇ ಕೂತ್ಕೊಂಡು ನಮ್ಗೆ ತೊಂದರೆ ಕೊಡ್ತೀರಾ ಇಲ್ಲಿ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಯ್ಯಟ್ಟು
Sorry, my lords. My apologies, my lords. Sir.
ವಾಟ್ ಅಪಾಲಜಿ ಬ್ರಿಟಿಷ್ ಹೋಗ್ಬೇಕು ಒಂದೇ ಕಲ್ಸ್ಕೊಟ್ಟು ನಮ್ಗೆ
Allah, the senior is held up with
ಮಾಡೋದು
other
ಡಿವೈಡ್
court.
ಮಾಡೋದು ಅಷ್ಟೇ
Senior ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ
ನಿಮ್ದು ಯಾವ್ದು ಅಯ್ಯಟ್ಟು ಇಲ್ಲ ತಾಯಿ ಇಲ್ಲಿ
ಅದು 31/7/2019 ಫೈಲ್ ಮಾಡಿದೀವಿ.
ಮೇಡಮ್ please remember we are not here to give any additional relief in the contempt shows violation if you don't show violation unnecessary you waste public time will impose heavy cost last time ಅವ್ರು 1 ಲಕ್ಷ ಹಾಕಿದೆ KPS ಗೆ ಈ ಸ್ವಲ್ಪ ಯಾಕಂದ್ರೆ ದುಡ್ಡು ಚೆನ್ನಾಗಿದೆ ಇವ್ರಿಗೆಲ್ಲ ಎಲ್ಲ AC DC ಲೆವೆಲ್ ಯಾರು ನಿಮ್ಮ DC ನ AC ನ
That's AC, my lords.
AC ನೋ ಪ್ರಾಬ್ಲಮ್ ಅವ್ರಿಗೆಲ್ಲ ಒಂದು ದಿವಸದ್ದು ಲೆಕ್ಕ ನಿಮ್ ಕೊಡೋ ಸಂಬಳ ನಿಮ್ ಕೊಡೋ ಫೀಸ್ Yes, ma.
My lords,
For the violation clause, they will dismiss with heavy cost, 2 lakhs, 3 lakhs minimum. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ ಇವರು? How many people are there? Violation ತೋರಿಸಿ, we will punish them. 5 ಜನ 2 ಲಕ್ಷ ಒಬ್ಬೊಬ್ಬರಿಗೆ 10 ಲಕ್ಷ ಆಗ್ತೀನಿ. ತಗೊಂಡೋಗಿ.
Therefore, I'm submitting, my lords, that they've complied with that, my lords. Subsequently, my lords, have filed an.
Madam, they have complied, there ain't the matter. If any constitutional benefit, you challenge separately, right?
That may be observed, my lords. Therefore, that is the
We will
only.
not observe, we will dismiss your application with heavy cost. Dismiss your contempt petition,
My lords,
show the
kindly,
violation, you are wasting public time.
my lords,
Yes,
kindly
what do you
pass
want?
over the matter, my
2
lords.
lakhs each.
My lords, kindly.
2 lakhs each. Okay. There must be limit to wasting public time.
My lords, kindly pass over the matter, my lords. Senior is held up in other court, my lords. We will.
ನೀನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ you want to take advantage, senior ಬರ್ತಾರೆ.
Hello,
This is all,
no.
you don't
My apologies,
disturb of advocacy. We will not tolerate disturb of advocacy, madam. You
My
can't take a
apologies, my
chance.
lords. ಅಲ್ಲ ನಾನು ಕಂಪ್ಲೈ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ದಿಸ್ ಇಸ್ ವಾಟ್ ಐ ಬ್ರಾಟ್ ಇಟ್ ಟು ಯುವರ್ ನೋಟಿಸ್ ಆಫ್ ದ ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್ಸ್.
ನಾನು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ ಇನ್ನೇನಿದೆ ಇಲ್ಲಿ?
ಅಲ್ಲ ನಾವು ಐಎ ಹಾಕಿದ್ನ ಐ ಸಬ್ಮಿಟೆಡ್, ಮೈ ಲಾರ್ಡ್ಸ್.
ಅಯ್ಯ ಹೌ ಇಸ್ ಮೇಂಟೈನಬಲ್? ಅಯ್ಯ ಫಾರ್ ವಾಟ್?
ಅದೇ ಡೈರೆಕ್ಷನ್.
Direction to what?
Shall I read it, my lords? May I read it, my lords?
Read.
Wherefore, the applicants most humbly praise that this honorable court be pleased to direct the respondent 1 and 2 to issue clarificatory order to the appointment orders already issued to the applicants in similar terms as that of Annexure A4 and A5, clearly spelling out the
Clarification ಕೊಡ್ಬೇಕು ನಾವು.
fixation of the seniority.
No, already enjoying the post. What the clarification you want? ಇಲ್ಲ ಮೇಲ್ ಕೂರಿಸಬೇಕು, ಇಲ್ಲ ಇಷ್ಟು ಸಂಬಳ ಕೊಡ್ಬೇಕು, ಇಷ್ಟು ಇದು ಕೊಡ್ಬೇಕು ತಾನೇ ಕ್ಲಾರಿಫಿಕೇಶನ್. How can we decide in contempt? Yes, ma. What do you want?
That is the application I had filed, my lords. Therefore, I brought it to your
No,
lordship.
we find nothing. We dismiss both the petition and application. The main order is violation. You are not shown any violation of 21/6/2016.
My lords, therefore, after subsequently we have said, my lords, they have complied, and this is the IA we had filed, my lords. Therefore, I submitted, my lords.
ಬಾಮ ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ. ಸಿರಿ ರಾಜಶೇಖರ್. ಯಾವತ್ತು ಹಾಕಿದ್ರಿ ನೀವು ಡೇಟು? So it's wasting public time, sir. ಕೋರ್ಟ್ ಕಾಳಜಿ ಬಗ್ಗೆ ಇಲ್ಲ, ಅವ್ರ ಕಾಳಜಿ ಫಾರ್ ಸಮಥಿಂಗ್ ಎಲ್ಸ್. ನಾವ್ ಹೇಳೋದು ತಪ್ಪಾಗತ್ತೆ. ಯಾವ್ದಮ್ಮ ಅಯ್ಯ ತಾಯಿ?
My lords, 31/7 ಅಲ್ಲಿ ಹಾಕಿದೀನಿ my lords. 2019 ಅಲ್ಲಿ ಹಾಕಿದೀವಿ.
ಎಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ, ನಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಸಿಗ್ತಾ ಇಲ್ಲ, ಇಲ್ಲೂ ಕಾಣ್ತಾ ಇಲ್ಲ.
My lords, my apologies my lords.
ನಮ್ಮ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲೂ ಇಲ್ಲ, ನಮ್ಮ ಫೈಲ್ ಅಲ್ಲೂ ಇಲ್ಲ. Where is that? You find in Pakistan. Rama, the present contempt petition filed, all the complaints, 5 complaints to take action against the accused persons under the provisions of section 11(12) Contempt Court Act for willful disobedience of the order passed by this court dated 21/6/2016, made in WP 27/674/2012 on connected matters, and confirmed by the Honorable Supreme Court dated 11/4/2018, made in SLP 29/2/9/2016, Annexure D. After arguing the matter for some time, Sri Rajshekar, learned counsel for the complaint, submits that subsequently the order passed by the coordinate bench dated 21/6/2016 has been complied.
Yes,
But they have filed for clarification of what? But the complaints filed subsequently an application for clarification.
a fixation of seniority my lords and promotion and
Seniority and
promotion ಮತ್ತೆ ಇದು consequential benefits my lords.
promotion consequential benefits. That is not the subject matter of the order dated 21/6/2016 passed by coordinate bench. If any other grievance subsequent order passed by this court confirmed the Honorable Supreme Court, it is for the petitioners, it is for the complainants to ventilate their rights, if any, in accordance with law elsewhere. We'll dismiss with cast, madam.
Please my lords,
The
my apologies my lords.
Nothing but abusing the process of the court. All these assistant commissioners.
My lords, my
all these
apologies my
assistant
lords.
commissioners. Yes, what you want? You want to withdraw, otherwise you'll impose 2 lakhs each.
My lords, my apologies my lords.
All right, come. Though the present applicants are fighting from 98, and this court had taken pains and granted relief by the order dated 21/6/2016, confirmed by the Honorable Supreme Court. But the complainants taking advantage of the court lenience and procedural defects, procedural aspects, filing application again and again is nothing but daring right on the court, merely because they are officers of responsible officer of state. They should also responsible toward the state as well as the court. Mr. Kodi, it is well said that it is well settled that today the judiciary is the repose of public faith. It is the trust of the people. It is the last hope of the people. After every knock at all the doors, faith people approach the judiciary as the last resort. It is the only temple worshipped by every citizen of this nation, regardless religion, caste, sex, or place of birth. To stop, the complainants approached this court, and this court granted some relief and affirmed by Supreme Court. If they are not happy, the orders pass, they should have challenged before the Honorable Supreme Court. Admittedly, the complaints, whether these people have filed as SLP, you he complainant. Admitted, whether you have filed as SLP against the order of the division bench.
My lords, I have to ascertain that my lords.
You are just playing fraud on the court.
My lords, I'm not aware of that fact, my lords.
Sri Rajshekar Learned Council, when a specific query was made by the court, whether these applicants are the have filed any appeal before the Honorable Supreme Court, he is not a person to answer. This clearly indicates everybody wants to misuse, abuse the force of the court without there being a right, and that too in the contempt proceedings. The attitude of the conduct attitude of the compliance, misusing the court time is deprecated. Therefore, we reject the contempt proceeding, the contempt proceedings as well as as protected with heavy cost. Next para.
My
In
lords,
the above, if we dismiss cost to 2 lakhs each.
lords,
Let
my
them pay.
apologies, my lords.
Huh?
My apologies, my lords.
Apology. Wasting public time.
My lords, my
We
apologies.
want withdraw. This is option, otherwise 2 lakhs each. What do you want?
My lord, sorry, I didn't hear that, my lords.
We want to withdraw. Otherwise, we'll dismiss with cost 2 lakhs each. Take it to Supreme Court. There must be a limit.
My lords, I'll ascertain, I'll take instructions and I'll submit, my lords.
At this stage, Sri Ashekar seeks passover to get instruction whether withdraw or she ready to pay the imposition cost. Passover.
Please, my lord.
Yes, who is else? All right. Yes. Narayan Bhatt. Asri. Shetty.
My lord, serial number 13, my lords.
Yes.
My lord, I'm appearing for the complainant in this matter, my lords. My lords, the advocate for the accused had sought time to file the reply, my lords.
Yeah, no, what is the direction?
My lord, there is a violation of the guide. There is a violation of the guidelines issued by the
Yenappa violation.
my lords. The complaint herein was arrested, my lords, and was produced before the magistrate, my lords. While producing the complaint before the magistrate, he did not fill the checklist was not produced as per the direction given by the Arnesh Kumar was the state of Bihar, my lords.
So file objections. File objections. File objections by the respondent. Yes. Yes, Batra. Yes. Sorry. Senior counsel for accused number 2 submit that the order for violation has been complied. Such submission is adopted 888 K. Manyat. Accused number 1. But 9 but 11 submit the order violation has not been complied. All the other submissions made through video process. Nobody is sure information to report the submission. Yes, sir. Show the record. It is the violation November. You are ready, Mr. Yes. Annexure. Annexure Q. Yes. Yes. With the fund number 2. All. With the respond number 2, have removed structure or not? When? When? Date already.
Month of January 2020. Month of December 2020.
ಯಾವ್ದು ಡೇಟು ಮಂತ್ ಆಫ್ ಡಿಸೆಂಬರ್ ಅಂದ್ರೆ ನಮ್ಮ ಓದ್ಕೊಂಡ್ ಬರಲ್ಲ ಮಿಸ್ಟರ್ ಬದ್ರಿನಾಥ್ ಒಂದು ಡೇಟ್ ಕೊಡಕ್ಕೆ ಒದ್ದಾಡ್ತಿರಲ್ಲ ರೀ ಏನ್ ಓದ್ತೀರಿ ಫೈಲ್ಗಳು December 2019. Yes. Yes, you have verified, sir. They are removed. Then what is the action taken by you? Why? Mr. Manjunath, paragraph 5 ಓದಿ ಪ್ಲೀಸ್ paragraph 5 ಓದಿ we are not concerned sir we are not concerned what is the complaint Mr. Manjunath single judge before not before us we are not concerned. We are concerned only paragraph 5. Please, whether you implemented or not, that's all. You frame the charge. That is your answer. Don't argue everything. Only concentrate this order. Salary. Where is that complaint?
6/1/2022. Statutory authority, they will be the first accused to pursue the application if filed by the second respondent for compounding of self violation in respect of the 16%. According to the second accused submitted an application on 1/12/2021 for compounding of the self violation. This accused considered the second accused representation dated 1/12/2021 and issued an endorsement of the 29/12/2021 with the details of the setback violation. And further stating that the regularization of violation of setback is not within a copy of the endorsement bearing number. This call also dated 29/12/2021 is issued by the accused second respondent for the year introduced by Karnataka Honorable Court. Therefore, the accused of the one placed the sound of the proceedings. That kindly now comes to the amount back. Endorsement itself. Usually, you will ask us straight away, turn to page 2.
Yes.
So now we have indicated what is violation. Where is that?
Mr. Manjunath, you have read your affidavit. That's all.
We have complained.
All right. We'll consider that. All right. All right. Now, if you have any patience, please come to page 61. 61. Paragraph 5. Nidana Kodi. The court did not say to you to find out violation. This court says, ensure, remove. Read that. Read the order. Please read the order. If that is your argument, we can't help it. We'll turn the charge. That's all.
Sufficiency of the invoice based on the fact. Respondent number 2 is obligated to remove the structure and ensure that the remove.
Please stop there.
Document.
Please stop there. Direction is respondent shall remove with the structure within 8 weeks and thereafter shall report to the same Post Fund Corporation. Within 4 weeks, thereafter, corporation shall ensure an inspection and satisfy himself with regard to complaints reported with respondent number 2. Have you inspected and have you reported complaints? Have you satisfied the remote?
No.
Then you are not done your job. ಮನ್ನಾ ಸಾಹೇಬ್ರೆ ತಾವು ದಯವಿಟ್ಟು ನಿಮ್ಗೆ ಅರ್ಥ ಆಗದೆ ಇದ್ರೆ ನಾವು ಕಾಂಟ್ ಹೆಲ್ಪ್ ಇಟ್. ಆರ್ಡರ್ ಇರೋದು ಅವ್ರು ತೆಗಿಬೇಕು ಅಂತ, ತೆಗೆದು ನಿಮ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ. ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ ಮೇಲೆ ನೀವು ಹೋಗಿ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿ ಅವರು ಮಾಡಿದ್ರಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಯು ಶುಡ್ ಸ್ಯಾಟಿಸ್ಫೈಡ್ ಎನ್ಶೋರ್ ಕಂಪ್ಲೈ ದಿ ಆರ್ಡರ್. ದಟ್ ಈಸ್ ದಿ ಆರ್ಡರ್. We are not concerned, sir.
After this matter, during the pendency of this circle, the master directed, if you want, you can have review of the other part. Then thereafter, during the pendency of this sentence petition, they move to the review of the other.
Whether this order is modified? ತೋರಿಸಿ ತೋರಿಸಿಯಪ್ಪ, ಇಲ್ಲಿದೆ ಪೇಜ್ 63 ಇಲ್ಲಿದೆ, ಅದೇ ಪಕ್ಕ ಮಾಡಿಫೈ. ಎಲ್ಲಿದೆ ಆರ್ಡ್ರು? ಎಸ್ ಈ ಆರ್ಡರ್ ಮಾಡಿಫೈ ಮಾಡಿ ತೋರ್ಸಪ್ಪ. ಇದೆಲ್ಲ ರೆಲೆವೆಂಟ್ ಮಾಡಿಫೈ ಮಾಡಿ ತೋರಿಸ್ಬಿಟ್ಟು ಮುಗೀತು. ಈ ಆರ್ಡರ್ ಡೇಟೆಡ್ 4 paragraph 5-6 is modified ಮುಗೀತು. ಅದು ನೋಡಿ 11 June 2009 paragraph 5-6 ಓದಿ ಎಲ್ಲಿ ಮಾಡಿಫೈ ಮಾಡಿದ ತೋರಿಸಿ.
I have scrutinized the memo and order. This was by disposing of the requisition, and neither considering the issue of property nor the second respondent, given any undertaking not to exercise the statutory. In that view of the matter, this court is of the considered opinion that the interpretation now being placed by the respondent that the order must pass from entertaining any such application does not allow any support by the reading of the order. Whether the application for property can be entertained or not is a decision that is to be taken by the statutory authority to whom the power to consider such application is vested. Hence, in my view, the instant application is premature.
Dismiss.
If such an application is made, it opens for the statutory authority to consider the same in accordance with the law. If the second respondent is returned by the consideration, it would constitute a separate cause of action. It is open for the.
Yes.
In argument, something we have not been filed. Memo, you are asked, I can take the mobile on 6/20. In argument, they gave a representation. Compounding of the violation. I also say subsequent order. Then when we consider it,
Mr. Manjunath, you are a senior member of the board. Application filed for modification, dismissed as premature. There is no modification of the order. The application for modification rejected. Sir, that is observation, sir. Not modified. Please read first para and last 6 para. That is the observation. General observation, not how modifying the earlier order.
ಯಾರು ಇಲ್ಲ ಈ second respondent. Consider ಮಾಡಿದ್ವಿ.
ನಮ್ಮ ಸಂಬಂಧ ಇಲ್ಲ ಸರ್. ತೆಗೆದಾಕಿ ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ಇರೋದು. You should ensure the removal of structure. That is the substance of the order. ನಿಮ್ಮ ಮಾಡಿಫಿಕೇಶನ್ ಹಾಕಿದ್ದನ್ನ the learned judge rejected, premature. and ಮಾಡಿ ಅವ್ರು ಏನಾಯ್ತು ಅದು not to you, separate ಅದು ಕಾದ ಫ್ಯಾಕ್ಷನ್ ಅವ್ರು ಕೊಡೋದು ಬಿಡೋದು ಸಪರೇಟ್ ಕಾದ ಫ್ಯಾಕ್ಷನ್. ಬಟ್ ಇಲ್ಲಿರೋದು ಆರ್ಡರ್ ರಿಮೂವ್. Why are not removed, sir? Somewhat content. See, not only this Bengaluru City Corporation, every corporation there antamandru ade buddhi. Yes, Mr. Badri, when did you remove? Where is the material? You have said your December 2019 you are removed. Where is that? 8/4. ಈ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ ಇದು ಫೈಲ್ ದಪ್ಪ ಮಾಡೋದ್ ಬಿಟ್ರೆ ಏನಾಗೋದಿಲ್ಲ. It is the mistake on the part of the brother advocate, sir. ಸುಮ್ಮನೆ ಫೈಲ್ ದಪ್ಪ ಮಾಡ್ತಾ ಇರೋದು. ಸೊ ತೆಗೆದಾಕಿದ್ವಿ ತೋರಿಸಿ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ. ಸರ ಹಾ ಮತ್ತೆ 15/10/2019 ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡೋದು 4 weeks ಟೈಮ್. ಎಸ್ ಆಯ್ತು ಬಿಡಿ 4 weeks ಅಕಾರ್ಡಿಂಗ್ ಐ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಐ ಆಯ್ತು 4 weeks ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದ್ರು. ಆಮೇಲೆ ಏನಂತ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅವ್ರು ಸ್ಟಿಲ್ ವೈಲೇಷನ್ ಅಂತ ಹೇಳ್ತಾನೆ ಇದ್ದಾರೆ. ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇಲ್ಲಿ ಮಿಸ್ಟರ್ ಬದ್ರಿನಾಥ್, entire paragraph 6 reading, you are not said acknowledge so on regarding removal of temporary structure ಅಷ್ಟೇ. address letter acknowledgement ನೀವು have removed on the so and so date in compliance order passed by this court ಎಲ್ಲಿ ತೋರಿಸಿ. ಇದು ಜಾರ್ಕೊಳ್ಳೋದು. ನಾವು ರಿಮೂವ್ ಮಾಡ್ತೀವಿ ಅಂತ ಲೆಟರ್ ಬರ್ದಿದ್ವಿ, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಅಂತ. ವೇರ್ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ we have removed on so and so date ತೋರಿಸಿ. No photograph, approve it.
Address and letter itself assures that it is a removed area. Any distinct connection after page number 5.
ನೋಡ್ರಿ, ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದ್ರೆ you know the mind of the sport.
Any distinct connection after page 5.
ಹಾ ಓದಿ.
Complaints order dated 11/6/2019 and 14/8/2019. So, Mr. M. Keeping with that, deputy professor against action seeking or direction to the survey part of the some report of directed I have sought for a directed issue of the paper. And then the honorable report of college to remove the temporary structure and keep it as per the direction. I have removed the temporary structure construction the complaint order of the order of the I annexed it. Relax copies of our past action. I have also produced the post of the development in the company. The letter itself had removed the temporary secretary just check it out. This letter had been addressed on 15/1/2020. They are removed in the first week of December itself.
Yes, Mr. Manjunath. The direction was permitting the private response remove the structure and ensure remaining structure in compliance with the sanction plan. And the second response shall exercise within 8 weeks and same to report to you. After report by him to you, have inspected, satisfied that he has removed the structure. Only there.
Not to violence. Undertaking cannot endure.
All right.
Yeah, we are remote the temporary structure.
We don't answer the court query, sir. Both are not answering court query. Simple direction, directing you to remove. And remaining portion, if it should comply with the sanction plan. ಅದು 4 weeks ಅಲ್ಲಿ ಮಾಡಬೇಕು ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆ. ನಿಮಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವು ಹೋಗಿ ಇನ್ಸ್ಪೆಕ್ಟ್ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಬೇಕು ವೆದರ್ ಯು ಆರ್ ರಿಮೂವ್ಡ್ ಆರ್ ನಾಟ್ ಅಂತ. ರಿಮೂವ್ ಮಾಡದೇ ಇದ್ರೆ ಯು ಶುಡ್ ಹ್ಯಾವ್ ಬೀನ್ ರಿಮೂವ್ಡ್. ವೈ ಯು ಆರ್ ನಾಟ್ ರಿಮೂವ್ಡ್? ಅಷ್ಟೇ ಸಿಂಪಲ್. Then you should have been removed. You should have been removed. Even contempt of the law. We will not give you any time, sir. We will from the charge. You are not violated. You are not to follow the procedure. ಸಾಹೇಬ್ರೆ, ನೀವೆಷ್ಟೊತ್ತು ಇವತ್ತೆಲ್ಲ ತಗೊಳ್ಳಿ ಇಬ್ರು. ಯು ಆರ್ ನಾಟ್ ಕಂಪ್ಲೈಂಟ್ ದಿ ಆರ್ಡರ್. ಎಂಟೈರ್ ಡೇ ತಗೊಳ್ಳಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಸಿಂಗಲ್ ಜಡ್ಜು ಡಿವಿಷನ್ ಬೆಂಚ್ ಕಂಟೆಂಪ್ಟ್ ಇದ್ರು ಇನ್ನೊಬ್ಬ ಜಡ್ಜ್ ಮಾಡಿದ ಆರ್ಡರ್ನ ಒಬೆ ಮಾಡಬಾರ್ದು ತೋರಿಸಿ. ದೆನ್ ವಿ ಆರ್ ನಾಟ್ ಕನ್ಸರ್ನ್. ನೀವು ರಿವ್ಯೂ ಇಲ್ಲ, ನೀವು ಓದಿದ್ರೆ ಇಷ್ಟೊತ್ತು ರಿವ್ಯೂನಲ್ಲೂ ಇಲ್ಲ. ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಜೆಕ್ಟೆಡ್, ಪ್ರಿಮೇಚೂರ್. ಬಾಮಾ, ಯು ಆರ್ ಫ್ರೇಮಿಂಗ್ ಚಾರ್ಜ್ both against these 2 people. Permission ಎಷ್ಟು ಕೊಡ್ತಾ ಇದೀವಿ ಸರ್? We will not grant you time. We will frame the charge. We face the magic. Mr. Manjunath, 11th June 2019, we are 22nd February 2022. Is the compliance 4 weeks? Even if you comply now, we'll impose cost on you. We'll impose cost on you. No, sir. You don't bother the court orders. Unfortunately, learned members of bar, they're supporting such a speculative litigations. You have to say something on the lawyer's conduct also. You are encouraging such type of litigants. If the order is bad, you should have challenged before the appellate authority. Order certified, over. ನಾವು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡ್ತೀವಿ, ಆಮೇಲೆ ನೀವು ಅದೇ ಸ್ವಾಮಿ ಪಾಪ ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ, ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬೆಲೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ನಾವು ಮಾಡ್ತಾರೆ. What do you mean, Mr. Manjunath? Prepare ಅಂತ ಹೇಳಿ. You have been directed to demolish. Where is the prepare? You are not giving any charter to the court. You will not thank you, Sakai.
Because there is a violation of setback more than 5%.
It is an unfortunate, it is an unfortunate case where,
Kindly, Mayor,
sir, you have heard you enough. ತಾವಿನ್ನೂ ಹೇಳ್ಬೇಕಾದ್ರೆ ಬರ್ಕೊಂತೀವಿ ಹೇಳಿ. This, please remember, contempt court is not meant for extension of time. ಅವ್ರ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೇಳಿದಾರೆ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಮುಂದೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿದಾರ ಅವ್ರು ಸಿಂಗಲ್ ಜಡ್ಜ್ ಎಲ್ಲ ಮಾಡಿದಾರೆ. No, sir. File affidavit. We will comply the order for the single judge within a week. File affidavit pass out. No, then we will pen the charge. Let him come tomorrow. After tomorrow. ನೋಡಿ ಮಂಜುನಾಥ್, ದಯವಿಟ್ಟು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. We are not against anybody. If lawyers are not cooperating, their own interpretation only will impose heavy cost on the litigants. And sometimes we may say conduct on the advocates also. ಅದು ಆಗಬೇಕು ಅಂದ್ರೆ ಮಾಡಿ. It's unfortunate, sir. You are all members of the officers of the court. If you don't obey, we will obey, sir. ನಾವು ಅವ್ರು ಎಸಿಡಿಸಿಗೆ ಹೇಳ್ತೀವಿ, ನೀವೇ ಮಾಡಲ್ಲ, ಅವ್ರೇನ್ ಮಾಡ್ತಾರ ಪಾಪ. It's unfortunate. Tomorrow, day after tomorrow. Let me start. Take the music. Okay. Yes, Nagaraj. Unfortunate, sir. ನಮ್ಮ ಹೆಲ್ತ್ಗಳು ಹಾಳು ಮಾಡ್ಬಿಡ್ತೀರಿ ನೀವು. ಓದಿರ್ತಾರೆ, ಹೇಳಿದ್ದೆ ಹೇಳ್ತೀರಿ. ಎಲ್ಲ ಹುಡುಕಿ ಏನ್ ಸಿಗಲ್ಲ. ಅದ KPS ಇದೆಯಲ್ಲ ಒಂದು ಕರ್ಮಕಾಂಡ, KPS ಇದು, ಅದು ಇಂಥವೇ ಇವೆಲ್ಲ ಕರ್ಮಕಾಂಡಗಳು. Unfortunate, sir. Now time has come, sir. Introspect ourselves, both the judges, lawyers, and the concerned officers, government. You are cheating the society for last 75 years. You are not giving anything to people. What is this, sir? ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ಪೇಜ್ ಮ್ಯೂಸಿಕ್ ಪಾಸ್ ಆರ್ಡರ್ ಅಷ್ಟೇ ಹೋಗುತ್ತೆ, ಮುಂದೆ ನಾವೇ ಮಾಡಕ್ಕಾಗತ್ತೆ? ನಮ್ಮ ಆರ್ಡರ್ ತಪ್ಪಾದ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತಗೊಂಡು ಹೋಗಿ. Yes.
Yes, Nagaraj.
Yes, Nagaraj.
My lord, I am appearing on behalf of the accused number 3 advocate, my lord, MB Prabhakar, my lord. He is not keeping well, my lord. That is the reason, my lord, I submit the
ಹೋದ್ಸಲ ಡೆವಲಪ್ಮೆಂಟ್ ಇನ್ ದಿ ಫ್ಯಾಮಿಲಿ ಅಂದ್ರೆ ಇವತ್ತು ಕೀಪಿಂಗ್ ವೆಲ್ ಇಲ್ಲ ಅಂತ ಏನ್ ಮಾಡ್ಬೇಕು? ಒಂದೊಂದ್ಸಲ ಒಂದೊಂದು ಬರುತ್ತೆ ನಿಮ್ಗೆ, ನಾವೇ ಮಾಡೋದು.
No, my lord, he is not well, my lord. Really, my lord, MB Prabhakar, my lord, is in not his station itself, my lord. That is the reason, my lord, I say that.
ಹೋದ್ಸಲ ಅವ್ರ ಮನೇಲಿ ಏನೋ ಡೆವಲಪ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇವತ್ತು ಹುಷಾರಿಲ್ಲ ಅಂತೀರಿ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಇನ್ನೇನ್ ಬರ್ತಾರೆ?
ಅದು ಇದೆ ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಸೆರೆಮನಿ ಇದೆ ಅಂತ ಅದನ್ನು ಹೇಳಿದ್ದಾರೆ.
ಅದು ಆಯ್ತಲ್ಲ, 15/4/21 ಆರ್ಡರ್ ಸರ್.
Please, my lord. One occasion, my lord, will give a last chance, my lord.
See the order passed by whom? Who passed the order, sir? You are virtually disabled.
Please, my lord.
You are virtually disabled.
Please,
Still you are misusing.
No, sorry, my lord. Sorry, my lord. I don't.
Sorry, mister.
Sorry.
ನಾವೆಲ್ಲ ನೋಡಲ್ಲ ಅನ್ಕೋಬೇಡಿ ನೀವು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಹಂಗಲ್ಲ ಸ್ವಾಮಿ, ಅವರು ಅನ್ಕನ್ವಿನ್ಸ್ ಬೆಳಗ್ಗೆ ಹೇಳಿದ್ರು, ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು, ಹಾಗಾಗಿ ನಾನು ಫೈಲು ಇಲ್ಲ.
ಹೇಳ್ಬೇಕು ನಾನು ಡಿಸೇಬಲ್ ಸರ್ ಅಂತ.
ಸಾರಿ ಮೈ ಲಾರ್ಡ್, ಸಾರಿ.
ನೋಡಲ್ಲ ಮಾಡಲ್ಲ, ಸುಮ್ಮನೆ ಹೊಡಿತಾ ಇರೋದು ನೀವು. ನಾವು ಕೇಳಲ್ಲ ಅಂತ, ನಾವು ನೋಡಲ್ಲ ಅಂತ ನೋಡಿ.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಫೈಲ್ ಇಲ್ಲ ಸ್ವಾಮಿ, ಹತ್ರ ಫೈಲ್ ಇಲ್ಲ, ನಿಜವಾಗ ನಮ್ ಫೈಲ್ ಇಲ್ಲ. ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಸ್ವಾಮಿ. ಅವ್ರು ಹೇಳಿದ್ರು ನನಗೆ ಹುಷಾರಿಲ್ಲ, ಅದೊಂದು ಹೇಳ್ಬಿಡಿ ಅಂತ ಹೇಳಿ. ಸಾರಿ ಮೈ ಲಾರ್ಡ್.
ಶ್ರೀ ಅವ್ರ ಹೆಸರು ಬರ್ಕೊಳ್ಳಿ. ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಸಬ್ಮಿಟ್ ಪ್ರಭಾಕರ್, ಲರ್ನರ್ ಕೌನ್ಸಿಲ್ is not well. Next week.
Apologize, my lord. Sorry, my lord.
Shiv Prakash.
My lord, I represent complainant. Repeatedly, I filed a memo also and brought to the notice of the Supreme Court. There are 4 contempt petitions. Only one is posted, and repeatedly there are 4 memos also filed to post all the matters 770, 71, 72, 73.
Contempt ಹೇಳ್ರಿ ಇಲ್ಲಿ, ಆಮೇಲೆ ನೋಡೋಣ, ಅದೆಲ್ಲ ಬರ್ತವೆ.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಅಲ್ಲ, contempt is order passed dated 23/4/2019 at Annexure A. Particular paragraph is 6, and in the internal page number is 76, my lord. 23/4/2019. My lord, in view of the aforesaid submission and for the reasons assigned by division bench of this court in the order dated 12/12/2018, passed in writ appeal so and so, and connected with the impugned communications are hereby quashed, and respondents are directed to permit the petitioner to complete the construction work within a period of 6 months from today, and thereafter to carry out the inspection so and so, so and so. My lord,
Yes.
in pursuance of this thing, when we made an application to give a commencement certificate, my application
Yes,
before
Mr. Council.
my lord,
I have filed an appeal against this order. When you filed your petition? After the contempt petition. ನೀವು ರಿವ್ಯೂ ಆಗಿದ್ದ ಅವಾಗ.
Annex re, my lord, review Annex re. This is disposed on 6th of August 2021.
Review filed an odd date, sir. You know? 6th August 21. Before filing CP. What happened? What happened?
Review, there is no order and there is no directions. It's only a disposal.
That's all. That's all. Mister, the order is not modified.
Correct.
The order is not modified, sir. Only observe. You can seek expect from the response, that's all. Order is not modified. For what? Mr. Counsel, please read para 6. That order is not modified. Merely because some observations made doesn't absolve. You obey the order, original order passed by the learned judge. Read again.
And for the reasons assigned by the division bench of this court, the order dated 12/12/2018 passed in discovery of the connected matter. The impugned communications are hereby quashed.
Stop and read. Stop and read.
The petitioners to complete the construction work within a period of 6 months from today.
You are being directed, permit the petitioners to complete the construction within a period of 6 months from today. Thereafter, to carry out the inspection, examine whether petitioners are complied with the conditions prescribed power purchase agreement and proceed the matter in accordance with law. Have you permitted the complainants to construct work within a period of 6 months? All right, come on. So, ನಮ್ಮ ಕರ್ಮ ಅಲ್ಲ. ಮಿಸ್ಟರ್ ನಾಟ್ ಶೋಸ್ ಇಷ್ಟೊತ್ತು ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಮತ್ತೆ ನಿಮ್ಗೆ ಹೇಳ್ಬೇಕು ನೋಡ್ಬೇಕು. ಪ್ಲೀಸ್. We are not on merit, sir.
Various conditions.
Mr. Senior Counsel, we are concerned with the direction issued by Leonard Singhal. Judge, have you permitted the petitioner to complete the construction within a period of 6 months or not? Remaining was once permitted, then go on. Whatever do, what you can do.
That was absolutely not.
That's a wonderful answer. Correct.
Therefore, not my submission. What is I have permitted them not.
Where is the permission granted by you? You are not prevented, but court directed you to permit these petitioners. Where is the permission in writing? Mr. Senior Counsel, please read again the order. Direct the respondents to permit the petitioners means you should permit them. Where is the writing permission? Construct within 6 months. Where is that?
What communication has not been sent. This one annexure R6. Consider this issue as to whether there is any specific written permission needed or not. And the Honorable Court has come to a conclusion that there is no written permission needed and they have to complete it within the time. That is not at page 13, annexure R6.
Some other judge. You are not concerned.
Therefore, not judicial pronouncement.
Correct, sir. Earlier judicial pronouncement certified by Leonard Singhal judge letter.
Also direction.
Please don't debate. We want to know this order passed by the Leonard Singhal judge is certified by the single judge. So a division bench, some other judge, some other proceeding said something. Do you mean to say earlier order have to ignore? That is your statement, Senior Counsel will record that. Sir, please, sir. We are not concerned subsequent to things. We are concerned the order obeyed or not. That's all. Whatever subsequent happened, we are not concerned. That is not before us. We only show compliance, that's all. Some other judge something, other judge says something, we are immaterial for us. Don't argue, sir.
Work commencement letter.
Yes, please.
There was an earlier amendment by annexure 18, page 29. The interpretation part, page 30.
Already, you may impose heavy cost and we will not leave this man. No, Mr. Senior Counsel, we are not happy the way our learned members of bar interpreting the orders. If the order is bad, challenge the order, set aside. If some order is passed by a single judge, some other judge pass some order, is binding. How can a single judge order and by other single judge can modify? Now, you simple answer ಕೇಳಿದ್ದು, have you permitted them to put up construction? Then the amount contempt will frame the charge. Mama.
I may be given some time or not. But after the bona fide impression law, that
Sir, you are a senior member of designated senior counsel. For senior counsel, where is bona fide impression?
and not interpreted by some report confirmed by division bench. Both orders are produced. But they have
It's a matter of evidence. If that is your argument, a matter of evidence, you frame the charge. Let him face the music, then we'll see. Bam.
But my humble request not is, we will try to not see what it could be resolved without.
Oh, Mr. Senior Counsel, what is the senior counsel? Everybody want to interpret. Nobody just ignore the order. Everybody want to interpret. Yes. Also, ಯಾವುದು ಇಲ್ಲಪ್ಪ, ಎರಡು ಹನ್ನೊಂದು ಆರ್ಡರ್ ಇಲ್ಲ. ಇನ್ಯಾವ್ದ್ರಲ್ಲಿ ಹೇಳ್ತಾ ಇದಾರೆ ನಿಮ್ಮ ಫ್ರೆಂಡ್ ನೋಡಿ. ನಾಟ್ ಇಯರ್.
There are 4 matters, all with the same orders, and there is no work commenced. And now they are
ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ತೀವಾ? Sir, what do you want, sir? You want to implement at that time, otherwise you pay the charge. We'll consider that. We'll consider approve, sir. This is the approve filed by you. 26/11/2011. We'll consider that. Done. 2/12/2021 approve. So what you have said, I filed review petition, we will consider noted earlier occasions. Mamuli ಹೇಳಿದಿರಿ. We will consider that. Bama. Mr. What is this, sir? The present contempt petition is filed by the complainant to take action as the respondent. To take action as accused 1 and 2 as causes of section 11(12) of Contempt Court Act for willful disobedience of the order passed by the learned of this court dated 23rd April 2019, made in WP 54004/2017, wherein the learned single judge, while disposing of the writ petition, passed a specific order as under para 6 extract 1. In response to the notice issued in present contempt petition, Sri Vasudeva, assistant engineer, Bescom filed the affidavit of compliance. It is stated that subsequent to the order passed by learned single judge, in the present writ petition, a review petition came to file in RP 496/2019, and it was pointed out the learned single judge has failed to appreciate various violations such as section 109 Land Reforms Act 1960, section 95 Karnataka Act, illegal leasing agricultural land, non-commencement of work as indicated in inspection dated 26/8/2016, non-commissioning of projects within 6 weeks, no technical feasibility of construction building without approval of deputy commissioner Gram Panchayat. The learned single judge was pleased to dispose of review petition with a clarification that it was open for Bescom to issue show cause notice seeking explanation from the complaint regarding the mentioned grounds in the previous show cause notice. Thereby, the accused number 2 submits order has been complied. All right. Bonda sir. Sri Shoprakash learned counsel for the complaint that the order passed by learned single judge dated 23rd April 2019 till today not complied. In the review petition filed, the learned judge has not modified the original order passed, but only permitted to the review page. Review petition, sir.
Section 4, my lord.
By the order dated 6th August 2021 in RP 496/2019, only clarified it is reserving liberty to the review petitioners to seek explanation from the respondent in respect of grounds which were mentioned in the previous show cause notice as well. The order passed Leonard Single Judge has not been complied, wherein the Leonard Single Judge directed the respondent to permit the petitioners to complete construction within a period of 6 months from the date of the order, and thereafter to carry out the inspection, examine the whether petitioners have complied the conditions prescribed in the power purchase agreements and proceed further in the matter in accordance with law. Hereby he sought to initiate contempt proceedings against the accused. For contrast, the Sriranga Learned Senior Council by the accused submits reiterating the affidavit filed by the accused number 2 submits that in portions of the order passed by the review petitioner dated 6th August 2021, permitting the present the accused persons, review petitioners therein, to seek an explanation from the respondent in respect of grounds which are mentioned in previous show cause notice as well. Thereby, order has been complied. Submission plus on record. First up, having heard the learned counsel for the parties, also given explanation, he further submits that the accused has the complaint also in show cause notice issued explanation. Thereby, order has been complied. First up, next order. Having heard the learned counsel for the parties, undisputed fact, this court by the order dated 23rd April 2019, made in WP 540004/2017, while disposing of petition, quashed the impugned communications issued by the present accused persons and present accused persons directed to permit the petition to complete the construction within a period of 6 months from the date of the order. Thereafter, to carry out the inspection to examine whether the petitioners have complied the conditions prescribed in the power purchase agreement, and to further proceed further the matter in accordance with law. In the entire affidavit filed by the accused, complaints affidavit filed by the accused, there is no whisper whether he has permitted the petitioners to complete the construction within 6 months by writing. Though the learned senior counsel for the accused tried to persuade us that there is no violation, the fact remains even the review petition on the review petition filed, the learned single judge has not modified the observations made, findings made in paragraph 6, observations made in the original order, except permitting seek explanation from the respondent in respect of grounds which are mentioned in the previous show cause notice as well. It will come only after the order is implemented. Thereby, it is a fit case to frame the charge. At this stage, Sri Lanka Learned Senior Council seeks time to get instructions to comply the order. Yavatu. Next week, comply the order or to frame the charge. Comply madi illa avatu barle, we will frame the charge.
My humble submission is there are other 3 matters. Let it be
Barli,
corrected.
don't worry, ಬರ್ತವೆ. ಅದೆಲ್ಲ ಮಿಕ್ಸ್ ಮಾಡೋದು ಬೇಡ ಬರ್ಲಿ.
ಅಲ್ಲ ಎಲ್ಲಾದ್ರಲ್ಲಿ ಒಂದೇ ಇಶ್ಯೂ ಇತ್ತು ಅದಕ್ಕೆ ನಾನು ಕೇಳ್ಕೊಂಡೆ.
Post along with Takri.
Memo is already filed. I'm obliged.
Yes, Hemant. What is the specification?
Declaration and injunction. In the pendency of the
Sir, where is the violation? Please show us. Yes. Read. Yes. Yes, where is that? Twentieth ಅಂತ ಯಾವುದೋ ಒಂದಿಲ್ಲಿ. Yes, Chairman. It's all right. Mr. Rahman, please, what is the order? Consider your grievance within 3 months. Sir, this is not writ appeal, this is not a PL. This is an order passed learned single judge, whether right or not. Now you have shown the learned single judge directed the accused persons to consider legal notice as well as your representation, pass orders. Now they have passed the order. If you are not happy, challenge that order. When did this start? All right, challenge that order.
This is one, 2 occasions there was controlled the property, petition property. So the 2021 is contract, because they are just saying before.
ನಿಮ್ಮ ಗ್ರೀವೆನ್ಸ್ ಏನಪ್ಪ ಹೇಳಿಪ್ಪ, ನಿಮ್ಮ ಗ್ರೀವೆನ್ಸ್ ಏನು ಹೇಳಿ.
Grievance is there, people problem, petition property, we are not using
ಎಲ್ಲಿದೆ ನಿಮ್ ಡಿಸ್ಪರ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ತೋರಿಸಿ ಆರ್ಡರ್ ಅಲ್ಲಿ. Then why you are arguing outside there? Only the point. Contempt is only implementation. That's all. Show us order ಮಾಡಿಲ್ಲ ಅದು ಮಾಡಿಲ್ಲ ಅಂತ ಹ್ಯಾಂಗ್ ಮಾಡಿ ಅವ್ರನ್ನ.
Just the actual order is they are not indicating. They are not indicating what it is.
Rahman, we record submission. Ultimately, don't blame the court. Will impose cost. If you don't understand what to do. ನಿಮ್ಮ ಗ್ರೀವೆನ್ಸ್ ಏನೇನಿದೆಯೋ ಎಲ್ಲ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇರಬೇಕು. ಅಲ್ಲಿ ಆರ್ಡರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಡೋಂಟ್ ಇನ್ಕ್ಲೂಡ್ ಸಮಥಿಂಗ್ ಇನ್ ದಿ ಆರ್ಡರ್. ಮಾಡಿದ್ದಾರೆ. All right, we'll consider that. All right, we'll consider that.
Is it the direction by the learned single judge
Mr. Rahman, either advocate or sitting judge, immaterial for us. Litigant is a litigant before the court. Equal treatment to all, respect of caste, creed. It's a temple of divine. You will follow my action. All right. The record also was submissions. All right. The record of submissions.
Second part of the person of the land, it was what about
Mr. Rahman, please read. The order course. Then, how can you argue beyond the order? The election public time will impose cost on your petition. Bama. Please remember, in the contempt only what is the violation. That's bit prapanchala argument. You are not here to tolerate. Everybody misusing the contempt proceeding. ಸ್ವಲ್ಪ ಇದಿರ್ಬೇಕಪ್ಪ ನಾವ್ ಬೇರೆ ಹೇಳೋದು ಬೇಜಾರಾಗುತ್ತೆ ನಿಮ್ಗೆ ಹೇಳ್ದೆ ನಮ್ ಸಮಾಧಾನ ಆಗಲ್ಲ ಮನ್ಸು ಎವ್ರಿಬಡಿ ಸೇಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕನ್ಸಿಡರ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ನೋ ದೇ ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಇವತ್ತೇ ಅವಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಇವತ್ತೇ ಪೋಷಣೆ ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡ್ಬೇಕು ನೀವು ನಿಮ್ಗೊಂದು ಮ್ಯಾಂಡಮಸ್ ಖುಷಿ ನಮಗೊಂದು ಮ್ಯಾಂಡಮಸ್ ಖುಷಿ ಶೋ ಇದು ಒಪ್ಪಬಾರ್ದು ಮಿಸ್ಟರ್ ಹೇಮಂತ್ ರಾಜ್ ಸ್ವಾಮಿ ನೀವು ಕನ್ಸಿಡರ್ ಬೇಡ I'm entitled. ಇಷ್ಟು ಅವಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು ನೀವು ಹೇಳೋದಲ್ಲ ನೀವು ಮ್ಯಾಂಡಮಸ್ ಕೊಟ್ರೆ ಸಾಕು ಖುಷಿ ನಮಗೂ ಖುಷಿ ಮ್ಯಾಂಡಮಸ್ Sir, what happened before that? Don't say that. Don't try to maintain some discipline. At least you don't maintain, we maintain. Why, mister? Within 3 months, why you are not passed the order or disposed of? We'll impose cost. Yes, talk about cost. Oh, 2 months, sir. 1 ದಿವಸ ಡಿಲೇ ಆದ್ರೂ ಬಿಡಲ್ಲ ನಾನು ನಿಮ್ಮನ್ನ ರೀಸನಬಲ್ ಕಾಸ್ಟ್ ಎಷ್ಟು ಅವ್ರಿಗೆ ಹರಾಸ್ ಮಾಡಿದಾರಲ್ಲ ಹೇಮಂತ ಎಷ್ಟು ಫೀಸ್ ತಗೊಂಡು ಅಷ್ಟು ಹಾಕ್ಬಿಡ್ತೀವಿ ನಾವು ಮತ್ತೆ ಹೇಳಿದ್ರು ನೀವೇ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ವಾಟ್ ಟು ಡು ಹಂಗ ನಾವು ಫ್ರೀ ಆಗಿ ಕೊಟ್ಬಿಡೋಣ ಅವ್ರು ಎಸ್ ಸರ್ ವಾಟ್ ದಿ ಕಾಸ್ಟ್ Who is this man? Executive engineer. Let him pay from his pocket. Yes, Mr. ಎಷ್ಟು ಕಾಸ್ಟ್ ಎಷ್ಟು ರೀಸನಬಲ್ ಕಾಸ್ಟ್ 1 ಲಕ್ಷ You are appearing, not Hemant Kumar. Kiran, you are not appearing. Accused number our good action respondents two you 2 to 4 includes 3. Where is your affidavit? Where that? Where is that? Sorry. 2 to 4. 2 to 4 ನೀವು ತಿಳಿಸಿದ್ರಲ್ಲ ಅವ್ರ ಅಪ್ರೂವ್ ತೆಗಿರಿ ಮೆಮೋ ಆಫ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ತೆಗಿರಿ ಈ ಅಪಿಂಗ್ ಫಾರ್ 2 to 4 ನೀವು 3 ಹೆಂಗೆ Like, the complainant filed the present contempt petition to take action against the accused by the powers of section 11 contempt court act for willful disobedience of the order passed by the Governor Single Judge dated 28th of May 2021, wherein WP 8971/2021, wherein the Governor Single Judge was disposed of the petition, directed the respondents present accused persons to address the grievance of the petitioner and consider the legal notice dated 2/12/2020 annexure H and pass appropriate orders in account law within a period of 3 months from the date of copy of this order. To stop, since the accused persons have not complied the order passed by Leonard Single Judge, the complainant was forced to file the contempt proceedings on 18/11/2021. This court, by the order dated 2/12/2021, issued notice to the accused person. In response to notice issued, the Leonard government advocate filed the affidavit of the executive engineer Yamot subdivision Kaveri Niravari Nigama Niyamita on 20th December 2021, filed the affidavit. Para 3 and 4 specifically stated as under. Thereafter, the accused persons engaged Prashant Bihar, the counsel on the panel, filed memo of compliance under the accused 2 to 4. They produced along with the memo the order dated 17/12/2021 passed by SLAO. The copies are produced Annex R1 to 3. Sri Yamath Raj, Learned Counsel for the complaint, contended that though the property acquired long back not passed any award and direction of Leonard Single Judge has not been complied, thereby the accused person is liable to be punished. To further contended, the Leonard Single Judge directed to consider grievance of the petitioner as well as the legal notice, pass order within 3 months. Since within 3 months they have not passed the order, thereby he was forced to file contempt proceedings, spending litigation expenses, and thereafter, during the pendency of the present contempt proceedings, now they passed the order only on 17/12/2021 after delay of 2 months. Thereby, they have deliberately disobeyed the order passed by the court. Therefore, he sought to allow the contempt proceedings. ಯಾರು ಬರೀಬೇಕು ಇವಾಗ? Sri Kiran Kumar, Learned Government Advocate, who filed complaints affidavit on behalf of the accused number 3 earlier sought to justify the order and contended order has been complied. Sri Prashant BR, who filed subsequent complaint on behalf of all the accused persons, also reiterated the complaints by the letter dated 1/12/2021, 30/12/2021, and order passed by SLO on 17/12/2021. Thereby, I submit as all compliant. Next para. Having heard the learned counsel for the parties, comma, it is undisputed fact the petitioner filed the petition before this court for three reliefs and contended that the grievance of the petitioner, that is legal notice dated 2/12/2020, not considered by the respondents, nor pass any orders, thereby he sought to mandamus. The Sri MRC Ravi, learned counsel for the accused number 2, 3, 4, who appeared and made a statement before the court that if the reasonable time is given, the respondents would consider and pass orders on the legal notice to stop. Thereby, the learned single judge disposed of the petitions and directed the accused persons to address the grievance of the petitioner as well as legal notice dated 2/12/2020, pass appropriate order within 3 months from the date of issue of the order. Immediately the order passed on 28th May 2021. The legal notice came to be issued along with the copy of the order passed by this court on 21/6/2021. The accused persons passed the order only on 17/12/2021. That too after contempt proceedings filed on 18/11/2021. This clearly indicates that the accused persons have no respect for the court order. First up, it is needless to observe, it is well settled that the parties approach the court. It is relevant to share at this stage that the component who approach this court after knocking all the doors failed approach this judiciary this court as a last resort. With the confidence that the judiciary is the repository of public faith, it is the trust of the people, it is the last hope of the people, it is the only temple worshipped by every citizen of this nation, regardless of religion, caste, sex, or place of birth. First up, when the complaint approached this court with all faith, when there is a direction issued by learned single judge on the concession made by the learned counsel for the accused, in all fairness, the accused should have been considered and pass orders within time stipulated. In spite of the concession made, the accused persons, they have shown their incorrigible attitude and not pass orders within the time. Thereby, the accused was forced to file thereby the complaint was forced to file a present contempt proceedings on 18 November 2021. After issuing notice, then only they opened the eyes and now they passed the order on 17/12/2021. Thereby delayed deliberately for 4 months. Thereby they are shaking the confidence of the litigant public and majesty of the court. It's nothing but abuse the purse of the court and degrading the majesty of the court. Therefore, the heavy cost has to impose on the accused persons who deliberately disobeyed 4 months only when the notice issued, when this court contempt proceedings pass some order, then only now they have waken up and pass the orders. this attitude of the accused persons is deprecated, thereby they are entitled to pay the cost. Stop. At last, by careful perusal of the affidavit and complaints memo filed, the accused persons, now the accused complaint, the order for the single judge passed the order on 17/12/2021. Stop. If the petitioner is not happy with the order passed by the accused persons, it's always open for the complaint to challenge the same, if so advised in accordance with law. Next part, in of the above, we pass the following order. The contempt proceedings hereby dropped, subject condition that the accused persons shall pay. Accused persons shall pay a cost of rupees 20,000 each by the accused number 2, 3, 4, that is 60,000 to the complainant within a period of 3 weeks, 2 weeks from today. Yenappa? We have agreed, not government. Government only for the state. 2, 3, you are the persons. All right, not 20,000, 50,000 each. Will impose 50,000 each. You are disturbing court order. Not only your accused persons disobey the order, you are interrupting the court proceedings. 50,000 each. We take the Supreme Court. Subject to payment of cost of 20,000 each. That is 60,000 payable by the accused person jointly together to the complainant within a period of 2 weeks from today. It is needless to observe. ಅವ್ರು ಜಾತಕಾಲ ಬರೀಬೇಕು ಅಂತ ಆಗಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲಿ. Yes. Prashant, please remember when you are dictating, you should not interfere. ಏನೋ ಹೇಳ್ಬೇಕು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ. That is obstructing court proceeding by the council. Announce ಮಾಡ್ಬಿಡ್ತೀವಿ ಅಷ್ಟೇ ನಾವು. Measure should go. Even if you comply belatedly, we will not tolerate. 4 ತಿಂಗಳು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ? Delay of Papa, delay of 4 months. 4 months ಆಗುತ್ತೆ ತಾನೆ. ಒಂದು ಡೇಟ್ ಆರ್ಡರ್ ಆಗುತ್ತೆ. ಒಂದು ಡೇಟ್ ರಿಸಿಪ್ಟ್ ಅನ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಅಪ್ಪ 3 months delay. 3 months delay. Yes. Rangnath.
My lord, I appeal, my lord. This is a case. Petitioner complainant is 71 years, my lord. 2008 he retired. Pensionary benefits were not granted. This honorable court allowed the petition on 1721, my lord, page number 10. 1721, the petition was allowed. With page number 28 is the direction to pay the pensionary benefits in 8 weeks from the date of the order. That is in July, my lord. Then I made a representation along with the copy of the order on 17th August. Now more
Yes,
than...
you filed an appeal.
Appeal is under office objection. Appeal was filed, my lord, belatedly. Appeal is filed January 22 and it's still office objection.
58, 20. I will not wait, sir.
January 22 file ಮಾಡಿದ್ದಾರೆ. After the time was over, they filed the appeal.
ನಮ್ಮ ಬಯಸ್ಕೊಳ್ತೀನಿ. ಆಗಲ್ಲ. Anybody, sir? We are not concerned. 8 weeks over on what date? 8 weeks over on what date? 31st August. 31st August ಎಂಟು ವಾರ ಮುಗ್ದೋಯ್ತು. Contempt filed on 18/11. New writ appeal filed on 14th January. 14/1/2022. This is after contempt. We will not wait. We'll pass orders. Come. We frame the charge. Sir, we can't. Circular is there. Circular ಕೊಡ್ರಿ. We will not facilitate, sir. ಅದರಲ್ಲಿ ಅಸೋಸಿಯೇಷನ್ ಹಾಕ್ಲಿ ಅಂತ ಹೇಳಿದ್ದೆ ಅವ್ರಿಗೆ ಸೆಕ್ರೆಟರಿಗೆ, ಅದು ಹಾಕಿದ್ರೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಲೆಟ್ ಲಾಯರ್ಸ್ ಆರ್ ನೋ ಅಂತ. ನೀವು ಸರ್ಕ್ಯುಲರ್ ಮಾಡ್ಬಿಡ್ತೀರಿ ಇವಾಗ ನೀವು. ಆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ರಿವ್ಯೂ ಬರೋದಿಲ್ಲ ಅಂತ. ದಟ್ ಈಸ್ ಸರ್ಕ್ಯುಲರ್. ದೆನ್ ನಿಮ್ಮ ಸರ್ಕ್ಯುಲರ್ ಇರೋದು ಹೇಳಿದ್ರೆ ಕ್ಲೀನ್ in order to protect the interest of citizens and clean administration and the interest of state government at the road. Sorry, circular number 3. Aggrieved persons approaches the court by filing contempt proceedings as the last resort, considering the court of temple of justice, and authorities unnecessarily cannot be allowed to adopt delayed tactics on the ground to file appeal or to file review or seek time before the court, which is impermissible. That is your circular, sir. No, not that time. You know? All right, buddy. It is yet another unfortunate case where the order passed on a single judge has disobeyed. Thereby, the present contempt petition is filed by the complainant to take action against the accused persons under the provisions of Section 11(12) of Contempt Court Act for willful disobedience of the order passed on a single judge dated 1st July 2021, made in WP 17/941/2012, wherein the learned single judge, while allowing the writ petition, quashed the order passed by the first respondent in RP 1 of 2011, dated 28/9/2011, and held the petitioner is entitled continuity of service and all incidental benefits, including areas of pension, taking qualifying service of the petitioner from the year 1990 to 30th April 2008, the date on which he has retired from service. The complaint should be made within 8 weeks from the date of the copy of the order. Since the order of the single judge has not been complied, the complaint was forced to file a contempt proceedings on 18/11/2021. The single judge directed to comply the order within 8 weeks by the order dated 1st July 2021, that is on or before 31/8/2021. To stop, the respondent accused persons are not complied, but very strangely, the learned government advocate submits writ appeal came to file on 14/1/2022, writ appeal 58/2022. That is subsequent to the order passed, subsequent to the contempt proceedings initiated by the complainant. Thereby, on the request made by the learned government advocate, 1 week time is granted to comply the order or to get an order in the writ appeal pending And this court will not wait since there is no order in the contempt in the writ appeal staying the operation of a single judge. Finally, 1 week time is granted to comply the order, or the accused person shall be present before the court to hear and frame the charge. Yes. You are the complainant. And then what happened? What happened, madam? Whether you are considered for the order? Who asked you to reschedule? You are not concerned. It is between you and the complaint. You are concerned the order. Read the order. Are you complied the order or not? Within 3 months. 3 months or 15 months. Yes, ma'am. For what? Come to BDA for what? What is your good name, madam? What is your good name? So, Rabi, read para 6 of the order. Moreover, where have reconsidered? Where have reconsidered? That is between you and the accused transaction. You are not concerned. Date may be given for framing charge. What? No. Your request is rejected. 3 months over by 15/7/2021. Now we are 22 over E. How many months delay? 15, 7, 8, 9, 10, 11, 12, 22. Almost 7 years. 7 months. 7 months. Yeah. Yes, 7 months over, ma. Will not wait. But madam, you are not granting any time. You should comply the order. Play the music. No question granting this court. So, under which provision you are seeking time? Your humble request, humbly rejected. Positively we are rejecting. Show contempt proceedings. Under each provision, court can extend time. We are not concerned. Between you and him, you can withdraw. Ask the complaint to withdraw. That's all. Before this court, once contempt is made, complaint is immaterial between complainant, the accused, and the court. You have to satisfy the court. That's all. You are passing the order. For compliance, 1 week. For compliance, only 1 week. Shall we record? No, ma, only 1 week. I am not working. Now, court should become rigid. Otherwise, ನಮ್ಮ ಅಪ್ರಾಣೆ ಸರಿ ಮಾಡಕ್ಕಾಗಲ್ಲ ಈ ದೇಶನ. ನೀವೆಲ್ಲ ನನ್ನ ಬೈಕೊಳ್ಳಿ, ತೊಂದರೆ ಇಲ್ಲ. ನೀವು ಬೈಕೊಂಡು ತೊಂದರೆ ಇಲ್ಲ. ಜನ ನ್ಯಾಯ ಸಿಗ್ಲಿ ಅಷ್ಟೇ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಬೆಲೆ ಇಲ್ಲ. ಎದ್ದು ನಿಂತ್ಕೊಳ್ಳೋದು ಟೈಮ್ ಕೇಳೋದು, ಎದ್ದು ನಿಂತು ಟೈಮ್ ಕೇಳೋದು. ಇನ್ನೊಂದ್ಸಲ ಅಫೇರ್ ಆಗ್ತಾರೆ. ದೇ ವಿಲ್ ಇಂಟರ್ಪ್ರಿಟ್. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಸಿಂಗಲ್ ಜಡ್ಜ್ ಆರ್ಡರ್ ಬೇರೆ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಈ ಜಡ್ಜ್ ಆರ್ಡರ್ ಕನ್ಸಿಡರ್ ಮಾಡಂಗಿಲ್ಲ. ಪಾಪ. The present contempt petition is filed by the complainant to take action against the accused under powers of 11-12 Contempt Court Act for willful disobedience of the order passed with this court dated 16/4/2021, made in WP 8194/2019, wherein the learned single judge was disposing of the endorsement issued by the BDA by the accused dated 29/2016 and remanded back the matter to the Assistant Commissioner by the Bengaluru Development Authority, Assistant Commissioner, Bengaluru Development Authority, to reconsider the claim of the petitioner after giving sufficient opportunity and after hearing the petitioner, pass orders in account within a period of 3 months from the date of issue of copy of the order. Since the complaint, 14th July. July representation. Within the 3 months. Accordingly, the complainant made a representation to the BDA along with the copy of the order on 14 July 2021. The BDA has to consider pass appropriate orders within 3 months from the date of the copy of the order. That is 14/7, 14/8, 14/9, 14/10. On or before 15/10/2021. Since the accused has not complied the order, the complainant was forced to file a present contempt petition on 20/11/2021. Even after 4 months, the accused persons have not filed any complaints affidavit. Madam Surbi, appeared by Vinnikishnan, filed memo dated 8/1/2022 that there is some correspondence between the accused, between the complainant and the accused. That correspondence is immaterial for the court. When the order passed by this court, the accused are bound to comply the order unless the order is modified or set aside by the higher court. First of admittedly, the order for learned single judge has reached finality even after last 4 months. On even after issuing contempt notice, the accused has not complied, thereby disobeyed the order passed by the court deliberately for a period of 4 months. At this stage, Surbi, at this stage, during the course of the dictation, Vinnikishnan interfered and made a submission that there is a correspondence between the accused and the complainant for the alternative side. Therefore, the 6th time, 1 week time is granted finally to comply the order, failing which the accused shall be present before this court for framing charge. Merely because we interrupt without permission from the court, we will not divide. ನಮ್ಮ ಸಂಬಂಧ ಇಲ್ಲ ಬೇರೆ ಕೊಟ್ಟು ಕಟ್ಕೊಂಡು ಇಲ್ವಾ ಮಾಡ್ತಾ ಇದಾರೆ ಅವರು. Why you are disturbing that? They are doing very well. ಅವ್ರಿಗೆ 1 ವಾರ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಅವ್ರಿಗೆ 1 ವಾರ ಕೊಡ್ಬೇಕು. ನಿಮ್ಗೆ 2 ವಾರ ಕೊಟ್ಟರೆ ಆ ಮಕ್ಕಳು ಎದ್ಕೊಂಡ್ಬಿಡ್ತಾರೆ. ಆ ಸೀನಿಯರ್ಗೊಂದು ನಮ್ಗೊಂದು ಅದನ್ನ ಮಾಡಲ್ಲ ಈ ಕೋರ್ಟಲ್ಲಿ. ಎಲ್ರಿಗೂ ಒಂದೇ ಧರ್ಮ. Survey, you are done wonderfully. Read properly and submit. Yes. Yes. Sorapa. After arguing the matter for some time, learner senior counsel, accused number 1 to 2 submit. Senior counsel has been engaged and is unwell thereby 6 time. If the council wants time, they should mention the same beginning itself. When the matter taken up, they cannot watch the proceedings and then seek time at the end. This attitude unbecoming counsel for the parties. Yes, sir. What is the violation? What is the violation, Mr. Ravi? Implementing of who appears for the accused? Accused. Who is the complainant? Sarvana. What is the violation? You are impleading. What is your role? Then ಮಾಡ್ಕೊಳ್ಳಿ.
The order of transit has been modified.
You are not the accused, sir. Why you bother? Accused ಬಂದು ಹೇಳಿ ಅದನ್ನೇ.
Come for the complainant in this matter, my lords.
Before the day, you should keep track of the then the commission to be and there was a direction to restore the land in favor of the landowners. Then pursuant to the directions, the others were restored in favor of the depleting applicant and other landowners.
Yes.
After restoring the, after cancelling the others, first standing of the complainant, the said order.
Ravi, what is the violation, Ravi?
Lords, this kind of practice is unheard of.
Don't ಬೇಡ ನಮ್ಗೆ.
ಅಲ್ಲ.
What is the violation?
My lords, the issue is very simple, my lords.
ಒಂದು ನಿಮಿಷ ಇರಿ, ಅವ್ರು ಮಾತಾಡ್ಲಿ. ಬಸ್
ಆಯ್ತು.
ಕರ್ದಾಗ ನಾವೇನ್ ಮಾಡ್ಬೇಕು?
Corporation cancelling the others which was standing in the name of the company.
Correct.
Then I find that the interview.
Again, the order of Lansing is dated 16th March 2021. Where is the writ appeal? Whether the order of Lansing is modified? ಎಲ್ಲಿದೆ? ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೀವು ಎಲ್ಲಿದೆ? ರಿಟ್ ಅಪೀಲ್ ಇದು ಓನ್ಲಿ 215. ಹಾ,
My land is concerned, I am not entered into any declaration deed or compromise deed.
ಅದನ್ನ ಇಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ.
Therefore, if the plan given in directions. It should not affect my rights. That's my interest.
That's what they said. Read 215. Vegan bencho. Whether you are supporting a complaint or supporting the accused.
I am neither supporting the complaint nor the accused. I want to protect my right. So far as the complainants are not supposed to be accused. Then in their name, in respect of my land.
You filed writ appeal. ವಿಜಯ್ ಶಂಕರ್ ಎಲ್ಲಿದ್ದಾರೆ? ವಿಜಯ್ ಶಂಕರ್ ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
1960/2013.
ಹಾ, ಇಲ್ಲ ಇಲ್ಲಿ.
Lords, page 175, my lords.
All right. You have 215 Banya Ravi. 215. Banya. 4 lines, 5 lines. However, the order so and so have been quashed in entirety. Alinda Odi. Therefore, we hold. Illa Adbeda. I told you.
However, the order status has been quashed in its entirety.
Correct.
Therefore, we hold that the opposite order held by the apparent.
Appellants. ನಿಮ್ಮ ಇಂಟ್ರೆಸ್ಟ್ ಕಾಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ. No. The order dated 19/4/2020 and 5/4/2020 by the ಅದು ಯಾವ ಆರ್ಡರ್ ಅದು? All right. We hold that the opposite order quashed to the extent held by the appellant before us, including your land.
The remaining lands, which are neither subject matter of any ratification agreement or any civil suit, would not be affected by this order, and its owners shall be free to use the same property.
Correct.
So, the findings here, Prashna can be compared to the right argument that page 195. My argument, 195.
Really?
Yes, I'm sorry to interrupt. I have not made him as an accused. Let's see, ultimately, the accused will have to come and say whether they want to implement the orders or not. I do not know what is the interest of these persons to come and speak for and on behalf of the, not after the notice was issued. It is the accused who has set up this person to go and say that you interrupt in the contempt proceedings so that we will not complete the orders.
We will not bother any interruption. Don't worry, sir. ನಮಗೆ ರೂಢಿ ಆಗ್ಬಿಟ್ಟಿದೆ ಇಂಟ್ರಪ್ಷನ್ ಮಾಡಿ 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 ನಾವು ಬಂಡ್ ಆಗ್ಬಿಟ್ಟಿದ್ವಿ.
ಅಲ್ಲ ಅದಕ್ಕಲ್ಲ ನಾನು ಹೇಳಿದ್ದು. kindly see the intention behind this. The intention of the accused is to protract the contempt proceedings by introducing these parties. They are the people who have set up these people.
No problem. Yes. ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಬೇಡ ಸರ್. ಇಲ್ಲಿ how you affected you, whether you affected, challenge. ಬಿಟ್ಬಿಡಿ ಆ ತರ ಕರ್ಸ್ಕೊತೀರಿ. ನಾವೇನು ಡೈರೆಕ್ಷನ್ ಕೊಡಲ್ಲ ಇಲ್ಲಿ. ಕಂಟೆಂಪ್ಟ್ ಡೈರೆಕ್ಷನ್ ಇಲ್ಲ, ಪನಿಷ್ ಮಾಡ್ತೀವಿ ಇಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಡಾಟ್ ಮಾಡ್ತೀವಿ. ನೋ ಡೈರೆಕ್ಷನ್ ಕಂಟೆಂಪ್ಟ್.
ವಿಕ್ರಮ್ ನಾಯ್ಡು
Correct.
Open to the parties to work out their remedy in relation to their right of right, title or interest in respect of lands in question before the appropriate forum. Such forum should be within the time of the party without being influenced by any of the observations made, either by the rights of subject or in this order. It is clarified that we are not expressed any opinion if you are the right side or interest of parties in respect of land in question, and therefore this question has in appropriate form. However, the additional commission of TPLD is also granted the given whole inquiry and ascertain the number of sites carved out of each number, which the assistance of the office of the Revenue Department and other than as supporting the existing matters as paid property tax as property which are registered and property tax is not paid.
ಅಷ್ಟೇ ಪ್ರಾಪರ್ಟಿ ಟ್ಯಾಕ್ಸ್ ರಿಕವರ್ ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ.
By the jurisdiction of the board to effect the revenue increase in the name of the company. The complaint.
Why you are arguing, sir? You just say what is your problem. You are arguing as rightly put out by the learned counsel. Again the complainant. So don't bother. To clarify, don't worry. Why you bother? Yes, yes. Single duty is qualified. What is the violation, Mr. Senior Counsel?
Lords, the issue is only this. The khatas were standing in the name of the present.
ನಮ್ ಸಂಬಂಧ ಇಲ್ಲ ರವಿ.
Implementation of the is within the situation that has not been brought to the rules of the law.
All right. Now, according to you, the complaint not only filed contempt petitions, he also filed upon the some other writ petition, implementation.
Implementation of the judgment of the errors in the state
All right.
has not been stated in the complaint.
All right. All right. Yes, sir.
May I, my lords?
Is it so, Mr. Ravi Shankar, you already filed one more writ petition, implement this order?
Lords, the writ petition was filed before the disposal of the writ appeal, because in the writ appeal, there was a specific order stating that the orders of the learned single judge should be enforced during the pendency of the writ appeal. Now, that writ petition would not survive because that order stands modified. The earlier writ petition was filed seeking the implementation of the single judge's order because there is an order by the division bench.
All right.
They sought for implementation of the orders by the division bench, which was an interim order.
What is the violation now?
But the violation is only this. By an order dated 19/4/2010 and 5/4/2012, the khatas were cancelled.
Yes.
And that order has been set aside so far as the present petitioners are concerned before your lordships,
Correct. Correct.
which is now clarified by the division bench. You know, this is an order which was passed. I just wanted to bring to your lordships notice that this is an order which was passed
Yes,
by
Mr.
the single judge on 13th February 2013. Not Mr. Devendrappa appears for the BBMP. They are the contesting respondent.
Sir, last time ಅದೇ ಆಗಿದೆ ಸರ್, ನಾವು ಯಾವಾಗಲೂ ಕಾಯಕ್ಕಾಗಲ್ಲ ಸರ್. Wasting public time. All senior counsels appearing now. You can't waste their time, public time. Tomorrow. No, sir. Wasting public time, sir. ಈ BBMP ಎಲ್ಲ ಕರ್ಮಕಾಂಡ ಇದು. BBMP ತೆಗಿಬೇಕಷ್ಟೇ. ಈ ಬೆಂಗಳೂರು BBMP BB ಎರಡು ತೆಗೆದಾಕ್ತಾರೆ AIDB. ಸ್ವಲ್ಪ ನೆಮ್ಮದಿ ಆಗ್ತದೆ, ಅಲ್ಲಿವರೆಗೂ ನೆಮ್ಮದಿ ಆಗಲ್ಲ. ಏನಾಗಿದೆ ಅವ್ರಿಗೆ? ಲಾಸ್ಟ್ ಟೈಮ್ ಹುಷಾರ್ ಅಂತ ಹೇಳಿದ್ರಿ. ವಾಟ್ ಹ್ಯಾಪನ್ ಟು ಹಿಮ್? So, Sri Ravi as well as Ravi Shankar, learned senior counsels for the complaint as well as impeding applicant argue for some time. Sri N. Tamesro, Pawan, learned counsel appearing for the accused number 2 and 3, seeks time on the ground. Sri Nanjun Reddy, learned senior counsel is unwell. Achieved his limit, achieved his request next week. Next week, Ushar on the Beret Ramanin.
Grateful, my lords.
Complaint, please. In action, A is the order at page.
ಕಷ್ಟ ಆಗ್ತಾ ನಾನು ಎಲ್ಲ ಕಂಟೆಂಟ್ ಕೊಟ್ಟಲ್ಲ. ಒಂದು 15 ರಾತ್ರಿ ನಾವು 20, 30, 100 ಹಾಕೋದೇ ಮುಗಿಸ್ತಾ ಇದ್ದೀನಿ. ಕಂಟೆಂಟ್ ಕೊಟ್ಟು ಆಗೋದಿಲ್ಲ, ಕಂಟೆಂಟ್ ತಗೋದಿಲ್ಲ, ಆಗಲ್ಲ. Yes, Shastri.
Page 15, my lord, is the order, my lord, where this honorable court directed the special land acquisition officer Moda, my lord, Mysore Urban Development,
Consider pass orders
to consider the application
4 months.
within 4 months, my lord.
4 months over on what date?
4 months were, my lord, over my lord, 16/5/2023/2021 is the order. So 22/7/2021 will be the
22/7/2021 expire. ಏನೋ ಆಗಿಲ್ಲ ಇನ್ನ.
ಏನ್ ಮಾಡಿಲ್ಲ, ಈಗ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವಾಗ ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ನೋಟಿಸ್ ಆಫ್
ವಿವೇಕಾನಂದ ಯಾಕೆ ಮಾಡಿಲ್ಲ? Vivekananda, is it a ground to seek time? Even if comply, delay is there, will impose cost. We will not leave anybody violate. Yes, yes. Good. The complaint filed the present contempt petition. The accused persons from the process of the 11-12 Contempt Court Act for willful disobedience to order of the single judge dated 23rd March 2021, made in WP 53100/2017, wherein the learned single judge will dispose with petition, directed the Muda accused to consider and pass appropriate orders on the application dated 16/5/2010, 22/2013, under the filed by the petitioners under section 28A1 of the Land Acquisition Act, in account within a period of 4 months from the date of receipt of the copy of the order. When did you file a representation?
Annexure B, I filed representation. Annexure D, I filed representation on 3/5/2021.
Accordingly, a representation came to file on 3/1/2021. Allinda 3 months.
Allinda 4 months.
4 months ಯಾವಾಗ ಆಗುತ್ತೆ?
ಅದು 2/9/2021 ಆಗುತ್ತೆ.
2/9/2021. The accused has to consider pass order within the stipulated time, that is on or before 2/9/2021. Till today, not complied the order. Thereby the accused was forced, both thereby the complaint was forced to file the present contempt proceedings on 24/11/2021. First up, today, Sri Vivek Learned Council for the accused submits that we will comply the order within a period of 1 week. Submission plus on the card, call next week. Even if you comply, we will impose cost. Achappa. Also unchecked file power accused. Award ಯಾವತ್ತು ಮಾಡಬೇಕು? ಯಾವತ್ತು? ಎಷ್ಟು ದಿವಸ ಆಯ್ತು ಇವಾಗ? ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ ಮೇಲೂ ಮಾಡಿಲ್ಲ. No difficulty, will not consider. Contempt court is harsh court. No representation, nothing. Only comply. Only comply. All right. 19/2/12. The present contempt proceeding initiated by the complainant against the accused on the to take action against the accused on the process of 11-12 Contempt Court Act for willful disobedience to order for the foreign bench of this court dated 19th August 2021, made in writ appeal 7/37/2018, wherein the learned single judge, while disposing of the writ appeal, directed the respondents to pass an award as expeditiously as possible within a period of 3 months from the date of the order. The 3 months elapsed on 18/11/2021. The order passed by the division bench has not been complied. Thereby, the contempt petition came to file on 2/12/2021. Even today, the accused has not complied the order. 2/12 December 2/12/2021. Even today, not complied the order. Sri so and so learned council seeks 1 week time, 2 weeks time to comply the order. Here they comply till there is a delay, and the court has to impose cost on the delay compliance also. 2 weeks time is granted. Single judge. 3 months ಯಾವತ್ತಾಯ್ತು? 12th July, August, September, October. 12th October ಮುಗ್ದೋಯ್ತು. ಇನ್ನ ಹಾಕಿಲ್ಲ. The present contempt proceedings filed to take against the accused of the cause of 11-12 contempt court act for willful disobedience to order of the single dated 12th August, July 2021 made in WP 10,238/2021, wherein the learned single judge disposed of petition directed the respondents PDA to address grievance of the petitioner and consider representation dated 16/2/2021 within 3 months from the date of the, this is a copy of the order. The copy of this, the representative made along with the order on 19/8/2021. The order should have been complied 19/8. Before 18/10, 3 months, 18/11/2021. Thereby, the complaint was forced to file the present contempt proceedings on 2/12/2021. At this stage, he sworn to 6 times to comply the order within a period of 2 months. But the fact remains, there is a delay. Cost has to be imposed. 2 weeks. Yes, Srikanth. Yes, Srikanth. ಎಲ್ಲಿದೆ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ. ಇದೇನಿದು? ಇದೇನ್ರಿ? ಇದೇನ್ ಕಾಪಿ? We are concerned only 28th May 2021 order. ಎಲ್ಲಿದೆ? ಸ್ಟೇಟ್ ತೋರಿಸಿ. Yes, who applies for the complaint? Srikanth, come. The present contempt proceeding is filed by the complaint to take an accused purpose and accused the following section 11-12 contempt court act for willful disobedience order dated 28/5/2021 and in WP 45/22/2021, wherein the learned single judge while allowing the discussion directed the respondents to consider representation of petitioner as per annexure C.D. and give effect of the sworn order on section 321(3) of the Act, and also further give effect to the order on section 462. Within a period of 4 months from the copy of the order. Since the order not complied, the accused, the complaint filed the present contempt proceedings on 6/12/2021. So and so learned counsel for the accused 1 to 4, you are Devendrappa. Rasabar Kalri. So, appeal by Devendrappa submits that against the order of learned single judge, a review petition came to file before the same learned single judge in review revision petition RP 62 of 2022. This court by the urging of this court by the order dated 21/5/2022 stayed the operation of the order dated 28/5/2021 made in WP 4522/2021 until further order. The same is Namotaka same is placed in the present record. Same is placed on record. In the above, we pass the following order. The contempt proceedings hereby dropped. However, needless to observe, it is always open for the complainant to file a fresh contempt petition after disposal of review. Revision 62 2022. And in account within with that 20 what is set aside. No, you are received on what date? How? You are there, government advocate there. Correct, government advocate to suspect immediate letter out there. Why you should wait for the petitioner, sir? Then what for government advocate represented? All right, 19.3. And 19.7. 30. Yes, yes, how the cost? ಯಾರಕ್ಕೂ ಹಾಕ್ಬೇಕು ಹೇಳಿ ಇಬ್ಬರಿಗೂ ಹಾಕ್ತೀನಿ ಎಲ್ಲಿದೆ ಇದು ಕಂಪ್ಲೇಂಟ್ ಸಬ್ಮಿಟ್ ಕೊಡ್ರಿ ಹೂ ಆರ್ ಫೈಲ್ ನೋ ಕಂಪ್ಲೇಂಟ್ ಸಬ್ಮಿಟ್ ಈ ಅಷ್ಟು ಪೇ ನಾಟ ಕೋಡಿ ಎಲ್ಲ ಮಾಡೋದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಅಲ್ಲ ತಹಶೀಲ್ದಾರ್ ಕೋಡಿ ದುರಸ್ತಿ ಮಾಡೋದು ತಹಶೀಲ್ದಾರೆ ನೋ ಅಪ್ರೂವ್ಡ್ ಫೈಲ್ ಬೈ ಹೋಮ್ ದೆನ್ ಇವಾಗ ಯಾರು ಇಬ್ರಿಗೆ ಹಾಕ್ಬೇಕ ಒಬ್ರಿಗೆ ಹಾಕ್ಬೇಕ ಅದಪ್ಪ ಯಾರ್ಗ ಹಾಕ್ಬೇಕು ಹೇಳಿ ಎಸಿ ಪರ್ಮಿಷನ್ ಕೊಡ್ಬೇಕಾ ಕೋಡಿಗೆ ಅಪ್ರೂವ್ ಅವನ್ ಮಾಡೇ ಇಲ್ವಲ್ಲ ಅವ್ನ್ ಮಾಡೇ ಇಲ್ದ ಅವನೇನ್ ಮಾಡ್ತಾನೆ ಅವ್ನ್ ಮಾಡಿದ್ದು ಅವನ ತಮ್ಮ ಇಂಪ್ರೆಷನ್ ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ ಕತೆ ಇಲ್ಲಿ ಇಂಪೋಸ್ ಓನ್ಲಿ ತಹಶೀಲ್ದಾರ್ ADR ADL ಅವ ನೀವು ADL ಒಂದು ಪಾರ್ಟಿನ ಮಾಡಿದ್ವಿ ಇಲ್ಲಿ ದೆನ್ ಯಾರು ಇಲ್ದವ್ರಿಗೆ ಹೇಳ್ಬಿಡಿ ಇದ್ದವ್ರು ಮಾತ್ರ ಹೇಳಿ ಸತ್ತೋದ್ರೆ ಬೇಕಾಗಿಲ್ಲ ನಮ್ಗೆ ನೀವು ಬದುಕಿದ್ರೆ ಹೇಳಿ ಎಸ್ ಮಿಸ್ಟರ್ ಕಿರಣ್ ಯಾರ್ಗ ಹಾಕ್ಬೇಕು ಕಾಸ್ಟ್ ಇವಾಗ ತಹಸೀಲ್ದಾರ್ಗೆ ಎಸ್ ಇಬ್ರಿಗ 6 months. 26 ತಿಂಗಳು 1,20,000. ಸರ್, ನೀವು ಇನ್ ಟೈಮ್ ಅಲ್ಲಿ ಮಾಡಿದ್ರೆ ಅವರು ಮಿತಿನ್ ಇಟ್ಕೊಂಡು 3 ಜನ ಲಾಗ್ ನಿಂತ್ಕೋಬೇಕಾಗಿಲ್ಲ. ಮಿತಿನ್ ಸುಮ್ಮನೆ ಕೊಟ್ಟು ಬರ್ತಾರೆ ಕಂಟೆಂಪ್ಟ್ ಅಲ್ಲ. ಕಂಟೆಂಪ್ಟ್ ಜಾಸ್ತಿ ದುಡ್ಡು ಎಲ್ಲದಕ್ಕಿಂತ ಹೆಚ್ಚಾಗಿ. ಅವ್ರು ನೋಡಾಕ್ತಿದ್ದೀನಿ ಬಾ ನೀನು ಅಷ್ಟು ಫೀಸ್ ಕೊಡ್ಬೇಕಾ ಅವ್ರಿಗೆ? The present contempt proceedings filed by the complainant against the accused to take action because of Section 1112 Contempt Court Act for willful disobedience of the order passed by the Governor single judge dated 20th February 2021, made in WP 4929/2017. ಅದು ಸ್ಟ್ರಿಕ್ಟ್ ಆಗಿ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಕ್ ಹೋದ್ರೆ 2016 ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು. ಐ ಆರ್ ರಿಚ್ ಫೈನಾಲ್ಟಿ. ಇನ್ನೊಂದು ರಿಟ್ ಬೇಕಾಗಿಲ್ಲ, ಅವಾಗಲೇ ಕಂಟೆಂಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು. ಮಿತ್ತಿನ ಇನ್ನೊಂದು ರಿಟ್ ಹಾಕೋಣ ಹಾಕಿದಾರೆ ಅಷ್ಟೇ. ನಮ್ದು ತಪ್ಪಿದೆ, ಲಾಯಲ್ದು ತಪ್ಪಿದೆ, ಕೋರ್ಟ್ದು ತಪ್ಪಿದೆ. ಈ ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಬೇಕಾಗೇ ಇಲ್ಲ. ಆಯ್ತು, the Lord single judge will disposing of the petition set aside the order passed by the Deputy Commissioner, Assistant Commissioner, and directed the revenue officials to implement the decision of this court made in WP 15/9/21/2016 dated 9/6/2016 in respect of undertaking 4D and Durasti within a period of 4 months from the date of establishing the order. It is relevant to say at this stage, this court in WP 16/9/21/2016 by the 9th June 2016 directed the respondents, the Tahsildar, Assistant Director Land Records, to continue representation petitioners as per Annex L to L1, L to L2 dated 26/12/2015, 5/1/2015, 18/2015, and complete the Durasti operations expeditiously as possible at any case within the outer limit of 6 months from the date of the issue of certified copies. Today's certified copy of the order, since the same was not complied, thereby second it pushing came to fight. To stop, even assuming when the order passed with this court on 25th February 2021, the same was brought to notice of the authorities by the complaint on 19/2021. If you have passed orders keeping in mind the earlier order possible single judge dated 16th 9/6/2016 not passed. Thereby, we should have passed orders on or before 19/7/2021, but they have not passed the order. Thereby, the present complaint was forced to file the present contempt proceedings on 14 December 2021. After issuance of notice, now the Tahsildar has complied the order on 31/1/2022. Elidado after delay of 6 months. Thereby, the Tahsildar not only disobeyed the order passed, earlier order passed by the Leonard Single Judge, dated 9 June 2016, made in WP 16/9/21/2016, and disobeyed the present order passed on 20th July 2021, clearly depicts the Tahsildar has no respect for the court order, thereby delayed the proceedings. And only after contempt proceedings initiated, when the order for the court issued notice and by the order dated 21/5/2021, on the undertaking given by the Leonard government advocate, the 2 weeks time was granted to report complaints or file reply. Today, the Kiran, Leonard government advocate, government leader filed the affidavit of Tahsildar, Devanalli, Bengaluru district. Now pass the order only on 31/2022. To stop. It is remembered actually. So as the last resort, people will come to the court. And the order passed by the Tahsildar is in violation of the circular issued by the state government dated 31/1/2022, made in number law /LAM/14 2020-22. Thereby, he dragged the complaint before this court, wasting not only the complaint has to spend litigation expenses, the mental trauma, financial loss from 2016, and on third occasion was posed before this court for the relief sought for. After repeated orders passed by this court, now the Tahsildar has shown his inclination to complete the order at last on 31/1/2022. Under the threat of the contempt, this clearly indicates that the Tahsildar has no respect for court orders. Though they obeyed after delay of 6 months, he is liable to pay cost for litigation expenses and the financial loss and mental trauma to the complainant. Thereby, we are inclined to impose heavy cost, but the government advocate proceeded to reduce the cost. First up, in of the above, we pass the following order. Accepting belated complaints, affidavit filed by the Tahsildar dated 31/1/2022, the contempt proceedings hereby dropped, subject to condition that the Tahsildar has to pay the litigation expenses and financial loss occurred on 3 occasions, spent by the complainant on 3 occasions before this court from 2016 till today. A sum of rupees 50,000 payable by him within a period of 2 weeks to the complainant, and report to the same to the registry, failing which for this matter for taking further action against the Tahsildar after 2 weeks. Yes, Madhu Babu. What is the office objection? Translation dispense with yes. Learned counsel for the complainant submits that under wrong notion the contempt proceedings filed prematurely. Thereby, you want to withdraw. You prefer to file a fresh contempt proceedings. Submission placed on record. In the above, contempt proceedings is disposed of or withdrawn with liberty to file a fresh contempt petition only after mature the order passed by a single judge. ಫಸ್ಟ್ ಸ್ಟೇಜ್ 45 ಕೇಸ್ ಹಾಕಿದ್ರೆ ಎಂತ ಮಾಡ್ಬೇಕು ಅಲ್ಲ ರೀ 36 ಕೇಸ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾವೇನ್ ಮನುಷ್ಯ ಇವರ ಸರ್ ಕಂಟೆಂಪ್ಟ್ ಮುಗಿಯಕ್ಕಾಗಲ್ಲ ಇವಾಗ ಇವತ್ತು ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ ಇನ್ನ ಗೌರವ Next week. ಮುಗಿದಂಗ ಮೇಡಮ್ ಇದು ಅಲ್ಲ ಈ ಡಿಕ್ಟೇಷನ್ ಮುಗಿದಂಗ